And let me see, so first order of business, I'd like to call to join me. Pledge of allegiance. Okay, with that, we'll have a roll call.
Here.
Here. Mr. Nader? Here. Mr. Sedison?
Yes.
Mr. Moss is absent. Mr. Johnson?
Here.
Thank you.
Okay, thank you. Okay, now we'll have a report from the planning director.
Good morning, Commissioners. Yeah, all of you. I guess I'm on there.
Just one second, sorry. I'll try to fix it my first.
So I'll speak, there we go. Now I don't have to speak on it. Anyway, good morning once again. A real brief report this morning. I just want to update you on the Board of Supervisors meeting this past week. On Tuesday, they considered once again the secondary dwelling ZTA, but staff had asked for a continuance at that meeting as we continue to work on language as directed by the board at their previous meeting. So that zoning text amendment is now scheduled for November 14th. At 3:15 p.m. That Board of Supervisors meeting is going to be held at the Community Development Resource Agency building. The other item that the board considered, they approved the final map for the Riola Vineyard Specific Plan Phase 1 project, which is titled Mariposa at Riola Vineyards. That's for 107 dwelling units. So the first, really the first final map approved for a specific plan in western Placer County. And that's it for the board meeting. Upcoming planning commission meetings, the November 9th meeting, we don't have anything scheduled for that, so we are going to cancel that. And then that leaves us with one meeting for the remainder of the year, which is going to be on December 14th. And right now that's scheduled down in Auburn. So other than that, if you notice, Karen Schwab is not here today. Elise Nielsen is, I don't want to say filling in, but taking that seat. So I expect to see more of her in meetings to come. So I want to welcome you, Elise. And that's all I have.
Welcome.
Thank you.
Any questions?
I have a comment. Yesterday at TRPA, we finally gave the final nod to Placer County's plan for Tahoe Basin, and we got accolades for a change.
I'm glad you brought that up. That did happen.
So that was a big
great
deal
deal.
yesterday, and everybody seemed pretty pleased with us at last. We had some highs and lows in the early going, but it turned out pretty well, and staff did a good job.
Perfect. Thanks for making that announcement. All right, thank you.
Okay, thank you. See, at this time, I give an opportunity to anybody in the public out there that has a comment on anything that's not on the agenda today. So if you have something that you want to say that's not on the agenda today, step forward. Okay, seeing none. then we'll move on to our consent agenda. So, let's see, we have a motion.
I'll move to approve the consent.
I second. Okay, do a roll call.
Mr. Haber? Mr. Rubin?
Yes.
Mr. Nader?
Yes.
Mr. Sedison?
Yes.
Mr. Johnson?
Yes.
Thank you. That was a motion by Mr. Sedison and a second by Mr. Nader.
Okay, let's see, looks like we're right on time. And so I will address the first item beyond the consent agenda on our agenda. And this is the Gary Davis Building Park item. And so Steve, you have the floor.
Good morning, Mr. Chair, members of the Planning Commission. I'm Steve Yolna with Planning Services Division. The item I'm bringing before the Planning Commission today is Planning Commission is being asked to consider an appeal of the zoning administrator's August 17th decision. And that decision was to deny the request from Gary Davis to modify the conditions of approval from the variance that was approved in 2002. Just by way of helping to orient the Planning Commission where this property is located, the subject property shown in the red outline on your screen is located in the southwestern portion of the Y in Tahoe City. The Y is referred to as the intersection of State Route 89 and State Route 28. The subject property itself contains a 4,621 square foot, two-story commercial building, which consists of professional offices and two residential units. The professional offices that currently exist at the property are GD Architecture Engineering, as well as Tahoe Luxury Properties. I may use Gary Davis Group and GD interchangeably. The business has changed names over the course of this project moving forward. So the Y intersection is located right here. This is State Route 89 that heads towards Homewood and Tahoe, and then State Route 28 veers off here towards Tahoe City. Subject property is located right in this area here. The parking for the site is located along the roadway frontage here, as well as 6 tandem parking spaces located here. This area here, including these parking spaces, is used for Tahoe Rafting gas. And then just for reference, this is where the Save Mart grocery store is located. In 2002, when the property owner acquired this property, they sought to do some redevelopment of the existing site, some building improvements. Included in those building improvements were facade upgrades, as well as enclosing this breezeway area here. The enclosure of the breezeway added additional floor area for the project. Because additional floor area was added, this resulted in an increased parking demand for the parcel. Also, with the increased structure improvement here, it eliminated these 2 parking spaces. So the 594 square feet that was added or increased to enclose the breezeway, plus the removal of the 594 square feet equated to 3 parking spaces being required, and it also resulted in the elimination of 2 parking spaces. Because of this, the applicant then proposed a variance to allow for there we go. The parking reduction and to allow for the expansion. The proposal for the variance, or the justification by the applicant, was that they intended to provide 5 off-site parking spaces located right here, which was on the Tahoe Rafting gas parcel. It's a little, I'll just note that the orientation between the aerials and the site plan is just a little bit skewed, so that might be a little confusing, but the parking along the frontage is, the roadway frontage is here, and here is our 6 tandem parking spaces. At the public hearing in 2002 for the variance request, at that time, staff recommended denial of the variance. The applicant also spoke providing their justification, and ultimately what the zoning administrator elected to do was approve the variance request. However, the zoning administrator was not comfortable with approving the variance request for the off-site parking spaces. Instead, the zoning administrator elected to ask for compensation by way of a condition of approval that I'll speak to in just a minute here, that would offset those 3 parking spaces that were required for the actual structural expansion of the unit. So the condition that the zoning administrator approved required that the applicant compensate for those 3 parking spaces. At the hearing itself, The zoning administrator did not have the actual dollar amount for how much it would cost to construct parking in the area. At that time in 2002, the county was undertaking new projects to construct additional parking in the area. So in rendering his decision, the zoning administrator indicated that he would consult with the Department of Public Works that was constructing these parking areas to determine the exact fee amount. The condition itself also provided a provision that should payment of the fees not be preferable to the applicant, that an alternate contribution of land, transit facilities, or off-site parking of equal value could be considered in lieu of the payment of what ultimately became $45,000. It's important to note that, however, that the last condition, or the last sentence of that condition states that the DRC, Development Review Committee, shall consider any such alternative and either approve or deny it. And that'll come into play later on in the presentation. In rendering this decision, because the zoning administrator did not have the exact dollar amount, he indicated that he intended to approve that, but would be issuing a finalized condition written decision that include the dollar amount, and then should that dollar amount be too high, that the applicant then would have the ability to appeal that decision. No appeal was filed. After the appeal period had ended on November 16, 2003, the applicant then authored a letter to the planning director that asked for a fee reduction for those parking spaces. It was the applicant's opinion that the dollar amount was too high, and that there was some analysis done with a study by Department of Public Works for the construction of parking facilities that would indicate a lesser amount. The planning director considered that request of the applicant, consulted with Department of Public Works, and determined that the actual cost for construction of parking spaces was more in the neighborhood of $10,000 as opposed to $15,000. So on February 6, 2004, the planning director issued a letter to the applicant that did reduce the fees to $10,000. So now condition number 4 would indicate that the applicant was required to pay $30,000 to move forward with this variance. On May 6, 2004, a building permit was issued that allowed for the facade improvements and the enclosure of that breezeway. Fast forward to approximately 10-11 years, the county received a complaint that indicated that condition number 4 had not been satisfied and that the payment had not been received by the county. The county advised the applicant of the potential violation and non-compliance with conditions of approval, and the applicant indicated that they had in fact paid the dollar amount but wasn't able to provide any documentation or receipt for that. County staff did research all payments to Community Development Resource Agency dating back to 2002. And while there were a few payments in the amount of $30,000, none of those were received from the Gary Davis Group or Gary Davis himself. The county advised the appellant of this, and the appellant then stated that the work his company had done 4 years prior on the bus shelter was intended to satisfy that other component of the condition of approval to provide transit facilities. Staff researched all records, including the application material for the bus shelter design review, and found no mention of this being the intention of that project moving forward, that it was intended to satisfy those conditions of approval. Further, there's no record of either staff approving, denying this request. There was no review of this inside the public hearing process or a response from the planning director similar to what had occurred with the fee reduction back in 2004. As such, the applicant then submitted a request to modify the conditions of approval of the variance from 2002 and sought to eliminate condition number 4 entirely from the project approval. Staff reviewed this request and brought it before the zoning administrator in May 10th, 2017, this year. And at that meeting, staff did recommend denial of the modification request. However, staff did provide some potential options for the zoning administrator should should he choose to grant this request. And those options were to either provide evidence of the payment of the $30,000 fee, or provide evidence that the county staff or planning director had acknowledged the request to provide the services for the bus shelter. The other two options were that perhaps the applicant could enter into a payment plan to satisfy the $30,000 fee that was required, or make use of the provisions that are contained within the new Tahoe Basin Area Plan that's recently been adopted, which would allow for the applicant to form a community service area and then make payments into that CSA to further the transportation efforts in the region. The zoning administrator took all of this into consideration, as well as the testimony from the applicant, and took action to deny the requested modification. And the applicant did file an appeal within 10 days. One of the arguments made by the applicant or the appellant is that there isn't a need for additional parking in the area. The next slides show 3 different snapshots in time with different circumstances surrounding the project area and surrounding properties. This slide here is from April 2014, and this happens to be outside the rafting season. The rafting season is where we tend to experience the highest traffic generation for the area, as well as demand on parking. And as you can see, there's a number of parking spaces that are available for folks to park in. Also, there's a limited amount of traffic on the roadways. About 8 years ago, here's a aerial of the project site. You can see during the rafting season, we've got the rafts down at the bottom on the Truckee River. There you can see that there's a number of more parking occupying the parking stalls, and slightly more traffic on the roadways. In contrast, this slide shows just several months ago, August 2017, and this shows again the neighboring properties and the traffic that's contained on the roadways during the rafting season.
Steve, was that on a weekend or during the week?
It's August 11th, so perhaps research of a calendar will offer that information in just a second. Right.
Friday.
So this vantage point shows the street view of the majority of the parking for the site, as well as you can see where this is where that breezeway was enclosed in the original application. It should be noted that the parking that's and one of the concerns of the zoning administrator in 2002 and subsequently in 2017 had to do with the parking design. This type of parking, while it's legal non-conforming, does not meet the parking standards of today, and there's concern of some of these parking stalls actually backing onto the roadway. Both zoning administrators for the hearings expressed concern over some of the parking concerns within the area. As I indicated, the applicant did file an appeal of the zoning administrator's decision to deny the request, stating 4 different reasons for the appeal. First, the appellant asserts that unique circumstances exist where there's sufficient parking on site, as well as in the neighboring areas. The ZA did consider this assertion from the appellant at the hearing, but was, and while the zoning administrator was understanding that the appellant does provide or encourage their employees to provide alternate modes of transportation, the ZA ultimately did not conclude that that alleviated the parking concerns for the site, as well as for the surrounding area. The next assertion of the appellant is that they had provided the bus shelter design in the amount of $40,000 worth of staff time for design, as well as permitting, to satisfy conditions of condition number 4. The zoning administrator also considered this assertion, but had the following concerns. One, there's no record of this agreement either inside a public hearing process or within the written documentation that would help to substantiate this claim. And there's no approval of the Development Review Committee of this alternative design that would satisfy the language contained within that condition. The zoning administrator was also concerned that the work was performed years after the applicant receiving the building permit to allow the construction to move forward. And finally, ultimately, the design of the bus shelter by the applicant appellant was not the design that was chosen to move forward for construction of the bus shelter itself. The appellant also asserts that there was a tacit approval that once the building permit and associated variance was issued and ultimately the final certificate of occupancy, that would indicate that the county had acknowledged compliance with that condition of approval. And while there was an oversight of county staff in the issuance of the building permit, and that condition should have been required to be satisfied at the time of the building permit issuance, the fact of the matter is that this does not absolve the applicant of their requirement under the conditions of approval to satisfy their conditions of approval. The last item raised by the appellant was that during the hearing, the May 10th, 2017 zoning administrator, that the denial of the variance, that the zoning administrator did not have all of the applicable information within the file the Planning Services Division had in their file, nor did it consider the other options as outlined in the staff's report. The zoning administrator, in rendering this decision, felt comfortable and satisfied with while he may not have had the actual timesheet accounting analysis that was presented to county staff, there was an adequate summary contained within the staff report for his consideration prior to making a decision, as well as the mention of the potential options for the payment, the community service, the CSA formation, and so on and so forth. Further, the mention of the potential to not have this information within the file was brought up prior to the zoning administrator rendering his decision. The zoning administrator ultimately took action to deny the request with this in mind, understanding that that would not have impacted his decision to move forward with the denial of the requested modification. So with all that, staff's recommendation is that you deny the appeal filed by Gary Davis Group. Staff would also recommend that you uphold the zoning administrator's decision to deny the variance modification as supported by the findings that are contained within your staff report. And with that, I'd be happy to answer any questions should you have any now or later on.
I just maybe have one question, and that you mentioned that there was an oversight in staff and that there would be the applicant of the requirement to pay the money or whatever. Is there any kind of statute of limitation on when something is supposed to be paid and at a certain time downstream that somehow you can't collect after that point? I'm sorry for the county council, but I'm just kind of curious about that.
That's okay, that's a good question. Actually, conditions of approval approved pursuant to a variance, they continue to run with the land going forward and forever. They don't extinguish or expire at any certain time. So continuing on going forward, the applicant or now appellant would be required to comply with those conditions of approval from here forward. There isn't an expiration date.
Thank you.
I have a question. Steve, how was this overlooked?
I couldn't really answer that. We did do the research of the building permit issuance, and there wasn't the requirement for staff to that acknowledge that condition of approval. So
Typically, they pay for this kind of obligation before the permit is issued.
the typical process would be that when the building permit was submitted, it would be routed through the county staff, and at that time, there would be a cross-checking of the conditions of approval for what would be applicable at that time. Unfortunately, it does not appear that cross-checking had occurred.
But normally, I'm saying that they
typically we would require that they either provide evidence or, if they haven't already paid, or pay at that time.
Thank you.
I know there's been discussion about what I would call in-kind services that supply. Is there any documentation anywhere where it presented for some agreement service that they provide?
Unfortunately not. We researched everywhere we could. We also asked the applicant, now appellant, that if they had any documentation that would help to substantiate that, to please provide that. But unfortunately, we do not have any record, like I said, either within a public hearing or with any correspondence, emails, anything of the like that would help to substantiate that they brought forward a suggestion that they provide these services and that the county reviewed it one way or the other.
And with respect to the services, is that still in place? In other words, and future services could be provided by the Gary Davis Group for some local project that would be some alternative that could be considered.
I believe so. And I know the audience may not have heard that question, but the question was,
Sorry.
whether or not a future proposal to provide some sort of in lieu fee work going towards that dollar amount, and that would still be consistent with as indicated by council, the conditions of approval move forward in time. So we would be able to consider a future request for that.
And has that been offered?
No.
Is that it? Okay, thank you. Let me see, at this time, Ellen, you step forward and take the microphone.
Good morning, Chairman, members of the Planning Commission. Steve, can I use your exhibit a little bit? I wasn't going to, but well, I was going to cycle through a few of them.
Left to right, and then the red button.
This is a good one to stop on, actually. This traffic you see, which looks pretty terrible, is based on the construction that's going on around the Fanny Bridge area for the Y that the feds are doing and Caltrans is doing. While we always do have August congestion, it's not normally that bad. But Steve was the original planner on this project back in the early 2000s and is the current planner. So he's got a pretty good history on this and put together, I think, a very thorough staff report. There's a lot of information in there. Probably a little hard to digest if you haven't been following the bouncing ball for the last 17 years, but I have. But I do have a couple things that I would maybe have a different view on than he has, so I'm going to back up a little bit here. Not that far. And this is the site, as he says, and pretty much through most of the year, we certainly don't have a lot of parking issues. That whole parking area surrounding it on several sides is the rafting company's property. They also own the Dam Cafe there, the River Grill, the little real estate office that was there, and those other cabins in the back. So 10 months out of the year, that parking lot is completely vacant. So we have total use of that parking lot. 2 months out of the year, sometimes a little bit less, sometimes in the drought years there was no rafting. We have use of the whole thing for 12 months of the year. Worst case, we usually have to deal with 2.5 months of rafting when the season's going full speed. So we don't, and have never had a parking problem in 17 years on this property, as evidenced by the number of cars in the front of our building, in the back of the building, and on the sides of the building during that 10 months when there's no rafting going on. So that's just one point I wanted to make. The tenants currently in the building, we have a 2-bedroom apartment with 2 people living in there. They don't own a car. We have a 1-bedroom apartment with a person who's there 50% of the time because he has another home in Tahoe. We have a real estate office, and as you know, most realtors don't work in the office that much. They're mostly working from their phone on the move. And then our engineers sometimes work from home. So we've never had a parking issue that we have to park on somebody else's property offsite other than the rafting company. this going back one stage here. The project in Tahoe City, we're probably one of the few buildings in Tahoe City in 20 years that has spent significant money to improve and renovate a 1950s building. We spent over $400,000 to do interior and exterior remodel on this building, which is an enhancement to our community. We get a lot of good comments on this building. For our less than the size of a 2-car garage, enclosing that space in the middle there, 590 something square feet, we already had a roof, a floor, 2 floors, and 2 sidewalls, and so we had to close 2 back walls. My contention was that the improvement was not commensurate with $45,000. And when I met with Fred Yeager, we had that discussion. He reduced it to 30 and gave me the option, because I said I'd rather even take the 30 and put it into the community somewhere than just put it in county funds, to do county improvements on transit. We did talk about employee or affordable housing as well, which is a big need in our area, and I would love to do something with that. But I know from the private industry side, being a civil engineer, that you can build 3 parking spaces at $5 a square foot for base rock and asphalt, which is less than $3,000. $3,000 compared to $45,000 seemed pretty onerous. Nonetheless, I would agree to the $30,000 with him and the option to do the public service type of project, which we'd already donated 2 bus shelters. The structural engineering, the 2 bus shelters are quite nice that Bruce built back earlier than this. I just want to get those points across. This is the parking. We inherited this parking with the building from the 1950s. Until they built the sidewalks in Tahoe City, almost all of Tahoe City had straight back out parking into the highway. So this is not something I caused. It came with the building. We realize it's not ideal, but if you were to turn that around and do parallel parking, we'd have 2 spaces. It's highly impractical for any building of our size to have 2 spaces. So these spaces do fit all the regulations in terms of size. We have had to put in a handicap spot with a drop-off, which took up 2 of our spaces. And those are 2 of the spaces that would have made the count perfect for the building without that. The zoning administrator, I don't want to linger on this too long, but George Wasowsko did not have the file with him that day. He understood he said this specifically in the hearing, that he had a complaint from the public, one person, a disgruntled former employee of mine, and that person would probably appeal it. And so he was basically not going to make a decision. He was going to send it to the planning commission. That's what George said at that hearing. I heard him say it. So anyway, I don't want to go any further here. I don't want to get that. So I just wanted to read a few things that I put together. I did send out an email yesterday morning to Sue to send to the planning commissioner, so we can have a kind of a condensed version here. I don't want to go through an hour of discussion on this. But let me just read this briefly, and some of it is a little bit different from what you received in the email. Many of the property lots in Tahoe City, if not most all, were formed way before Placer County planning rules as well as TRPA coverage rules were in place. Most would not fit current parking rules. In fact, before the sidewalk project 20 years ago and Tahoe City got built, most of the businesses had to back out onto the road. Therefore, that is the exact intent of the variance process, is to deal with things that don't fit neatly into a black and white box in current rules. The staff report that the spaces do not meet design standards for circulation is correct, and we inherited that. The building inherits 1950 design standards and is impossible to meet today's Caltrans or county standards. Nonetheless, it works. It has worked well over our little corner of the community for 17 years that I've owned the building. With today's parking rules, we probably would have 0 spaces in front. One other twist to that is that the new highway project going on at the Y is going to create a roundabout there, and there's actually going to be a parking island in front of our building, which will alleviate the backing out into the highway. We'll be on a little side street, more or less. I bought the property in 2000. I've invested more than $400,000 in renovation of this 1950s building. It's currently fully modernized, meets ADA requirements, and is an asset to our community. It's one of the few buildings that's been upgraded in Tahoe City in the last 20 years. the process and costs associated with TRPA and Placer County make it difficult for small property owners to invest in the community. We feel strongly about investing in the community. With the need for a bit more space, we enclose that area, and that is the result of the need for more parking spaces, the 3 that were indicated in the original variance. The addition of 590 plus square feet by itself would technically require 2 parking spaces. When added to the rest of the building, it required more parking spaces. Since 2000, I had a cooperative agreement with my immediate neighbor to use his large parking for any overflow needs when their rafting business was not operating. As well as Steve mentioned, I offered public transit passes to all my employees any time of the year they wanted to use the bus. I built a bike rack for employees so they could bike in, which a number of them do in the summertime. And I did attach that current agreement with my neighbor, Bell Properties. The original variance staff report required that we pay $15,000 per space for 3 spaces. And I talked about what the actual cost would be at $5 a square foot to actually build something on the ground without buying the property, less than $3,000. When I talked with Fred Yeager, the planning director at the time, who was the ZA at the original variance hearing, we had lengthy discussions. We had a number of letters back and forth, some emails, and at the end of the day, he agreed that he could reduce the cost and would accept the option of doing alternative community service that would enhance parking. It was limited to transit facilities is the way it was spelled out, but I also wanted to do something for affordable housing. So that was the intent, really, not to pay ever the $30,000, but to pay in lieu fees or lieu services. That was always the intent, and that was what we had preferred to do, and Fred understood that the money going to the county pocket would probably not put much on the ground versus what we could do as a private entity putting stuff on the ground. That is documented on the handwritten notes on that original variance from 2002 that's in your file. Fred's notes aren't on that one. And I don't know if I misheard this, Steve, but I never said that I had paid the $30,000. Did you indicate that I said I paid that one time? No, I had never, ever said I paid it. Never. The concept was discussed to add additional bus shelter at the Safeway property. That was part of our planning effort in the town, that we wanted to have a 3rd shelter that kind of bookended the other end of town, where the 2 other really nice shelters are the going in the end of town from Squaw. The idea kind of lead fallow for a number of years. They did sign off on the building permit. And I assumed that was because they understood the intent was clearly not to pay the $30,000, but clearly to do the in lieu. That was always the intent. And that was the intent that Fred and I had agreed upon. We took charge of the design. My office spent quite a bit of time on the design effort. We got permits from Placer County Building Department, Placer County Planning Department, Placer County Design Review. We got permits from TRPA. We got permits from Caltrans. We got permits from the Tahoe City Public Utility District to use their electricity. So we designed it, we had it permitted. Then we went through a funding process that started with CAT, the Contractors Association of Truckee Tahoe, and they were willing to get donated materials from Truckee Tahoe Lumber. They were willing to get labor from various people in their organizations who wanted to do a community project, and they were willing to manage the project. We still had a big funding gap. NLTRA was willing to approve $60,000, which they did through the Infrastructure Committee, and then finally their board, to be sent on to the Board of Supervisors for final funding. So the steps going through this were get a design, obtain approvals and permits, get funding, and then go to Placer County Design Site Review for final approval. There's no reason in the world Placer County Design Site Approval would not have approved this project. And some of them sit here today, I think, could tell you that would be almost an automatic slam dunk because it's consistent with what we've been doing. So that wasn't done at the start of the process. That was going to be done at the end of the process because it didn't matter if we didn't get funding and we didn't get permits from the appropriate agencies. We took that to the level to get the final funding, which was stifled in the end by a last-minute announcement that we were going to have to pay prevailing wage. That was right before winter hit. energy kind of got lost on the project over the winter, and we could not get the contractors back to deal with the prevailing wage issue in the spring because they all were so busy. Or we would have gone forward and we could have solved the prevailing wage issue and we would have had that built. As it is, Placer County used my permits that I paid for out of my pocket. They used some elements of the design, although it's certainly not as elegant as we had hoped it to be. But it got done, which is still a good thing. And I was not trying to ever avoid the in lieu. We have the time cards that are also in your packet there that show a minimum of $40,000 of time staff, and it doesn't even count most of my time, which was talking with CAT members and on site with other contractor people. I took all the necessary steps to complete my obligation. Had the 11th hour issue of prevailing wages not been brought up, this would have been built. It would have been approved by the Placer County Design Site Review Committee, I guarantee you, and it would be built there today with the quality that we had in mind for our community. The planning department signed off on the building permit. I think I talked about that. I thought that would be tacit understanding of where our intent was going. And I think that is just about all I have here. I'm looking for the flexibility of the variance process to provide a solution. Certainly staff is constrained by the rules and ordinances in the planning documents and don't have the ability to make these kinds of judgment calls. That's why we have a variance process. Not everything in Tahoe City, which is an old town, fits neatly into a box of the one-size-fits-all planning requirements. So whether it's a reduction of fees, in this case, a consideration of what has been donated to date, or even a future project to get something on the ground in Tahoe City, I would very much appreciate your consideration of that. The bottom line is I would hope that Planning Commission would recognize the agreement with former planning director for the original variance and recognize the expensive efforts and contribution we spent to accommodate my side of the agreement. I would think it's obvious that we would not have gone down this path to design and build a bus shelter for my community just for fun and spend over $40,000. I do donate a lot to the community, but that amount would have been over the top even for me. So I'm certainly open to any questions you might have.
Just one here. When did you start working on the design of the bus shelter? Just what year?
I can't say. I'd have to go back and look here, but I think the preliminary design was some years after the original variance. I can't remember exactly. And we had a recession in there and things.
Okay, then my follow-up question, I'll let you fast one. Between 2002 and sometime later, just forget that you had this $30,000 obligation.
No, I never forgot about it. My obligation in my mind and what I had agreed to with Fred in discussion was to build something, to get something built. That was my obligation. I was not intending to pay $30,000. I was intending to do something for the community in that value.
Thank you.
Gary, I've got 3 questions for you. Obviously, when you did the improvements to the building, as I understand from what Steve's presentation is, you lost 2 parking places because of the addition. And then if you add the extra square footage of the addition, then obviously, you know, through their formula, they're saying that there needed to be another, at least 1 more parking space. So to me, 3 parking places, maybe there's a logical path to that.
Yes.
And so I'm asking you that sort of question. I'm kind of putting that out there. It seems that the county's reasoning was not out of line.
No, in terms of the math, considering the ordinance and the planning documents, that's certainly consistent with that. My argument was that in reality, on the ground, even today, we don't have that need, but that certainly doesn't fit within the zone.
My second question is that if I heard you correctly, as you were negotiating with Fred Yeager, that you agreed with the $30,000 amount. As you just pointed to Steve and said you didn't agree to pay it, you know, out in actual dollars. You did agree that that was an amount that you could come to terms with.
That's correct in view of having the ability to trade out for in lieu. But what I was referring to is that I didn't say I was never going to pay it. Was in talking to Steve, we're referring to, I think, more recent, this last year, while this complaints come forward, is in many conversations that I've had with county staff and Michael Johnson, our former planning director, and Jennifer Montgomery. I never told any one of those people that I had paid it. So I want that to be clear, that I never made that statement, I've paid this money, therefore I owe nothing. I've never said that. So yes, that obligation is still consistent with the original variance, which gave me the in lieu option.
Okay, thank you for clearing that up. My last question is, based on Steve's report, there's really no documentation out there that the in lieu work that you did was ever accepted by the county as a trade-off for the $30,000 obligation.
That would have been the last step after funding. We had the whole package. We had the permits, approvals from all the agencies, and the funding. Then we could have gone to Placer County Design Site Review, which would be a cursory review and approval, in my opinion. That would be the necessary last step, not the first step.
Wouldn't you have wanted to have assurances that you had documentation that, as you were obviously making a significant investment in this, that there was not going to be a question of what you were doing was going to offset the obligation? Because apparently there's just not a real good paper trail on this one to say that the work that was done really was going to satisfy that.
It seemed pretty consistent with my understanding and from our two previous bus shelters that were donated by Bruce Olson in Tahoe City, that design site review was not really an issue. And for another donated shelter that provided $150,000 worth of value for zero cost to the county, would be pretty easy for them to absorb. It just didn't even seem to be a question in my mind. I don't think they would have an issue with that.
It would be helpful if there was better documentation.
Oh, absolutely, in this retrospect, of course. And of course, Fred retired down the road there too, so that did help.
Any questions?
Yeah,
I wish Fred was here. I wish Fred was
right
here.
there. Excuse me. I just want to be clear here. So, as I'm understanding it, both from Steve, that conditions over the land, and to indicate you would be willing to donate services going out on some project. Is that correct?
Yeah, I'd like to see some credit for what's been done, and 100% credit would be the best I would hope for. But I'd also be open to discussing some other further improvements. There's another parking lot that is Peter Kratz is working on for the back of the commercial row. I'd be happy to contribute something in that effort. I'd like to see something on the ground for our community.
When you say something, though, it's still, as I understand, this is still a $30,000 obligation. Is that something you would pay to $30,000 services?
Yes, if the county was not willing to give me any credit for the $40,000 I've spent, I would certainly entertain some efforts toward $30,000 towards another project. But I would like to see something again on the ground and not just go into the county coffers and disappear. Or do another study that shows we need parking.
Okay, well, we'll get back to you at some point in time, so this time, thank you.
You're welcome. Happy to answer any other questions.
Now I'll open up to a public comment.
Good morning, Ellie Waller, Tahoe Vista resident. Thanks for coming to Tahoe today. A couple of things. I've turned in similar comments starting May 10th. I thought the hearing was going to be the 12th. When I was out of town, I will resubmit with the correct date for October 26th today. My comments for the public as well as you today, I actually had the opportunity to work for the adjacent rafting company, not the one that Gary uses or was going to have the availability. There are parking problems during that up to 3 month season. I was the parking management attendant. I worked up to 6 days a week. The traffic is horrific. The parking is a nightmare, the backing in. Secondly, this isn't about the parking issue. It's about a formula and how much should be paid. I will repeat that it's calling bartering of services for in lieu fees. This is not something that's on the books or codified. If this is going to be something in the future, we need to have staff bring this forward as an available option. With that said, I applaud Gary for all the work that he's done in the county. Again, there's no documentation, as many of you have asked or brought forward. There was no complaint about the verified legal resident units there. That's a whole nother issue that doesn't need to be brought forward today. But the parking number, again, is a formula because the intent of what full occupancy could be. I want you to be very cautious about setting precedents, about some of the requests for doing this. Again, if you choose to allow future work by the Gary Davis Group, I think, again, we need to be very cautious. Somebody else could come forward. We need to get something like this codified. Thank you very much.
Okay, thank you. See anybody else? Well, I'm not seeing anybody stand up out there. I think at this point, I'll close the public hearing. Gary, do you have anything further to say? Okay, I'll bring it back to the commission.
Everybody looks at me.
You're the local guy.
Well, that's because you're moving.
There's two of us here. Well, I think it's an unfortunate situation. It should have never, unfortunately, the permit for the expansion should have not have been ever issued until this was resolved. And it's just too bad that it got this far, because it probably in advance it could have been resolved and everybody would have known. I would frankly wish Fred was available to us to confirm the comments, because it would. If I'd have known, I just saw him at a funeral the other day, I would ask him. But at any rate, I'm not sure how we can get from where we are to where we'd like to be and have this resolved. I think we have some egg on our face because we didn't force the issue at the time, and when the permit was issued, we should have just said, well, you can have the permit when we get this money issue resolved. And instead we went ahead and issued a permit, and he relied on it to do improvements. But now we're sitting here without the benefit of the mitigation, either parking or money or whatever. And I'm not sure how we back this train up and get us back to a point where there's something that can be agreed upon by Gary and by the county together that's an acceptable solution. I know we've got legal constraints, we've got other issues that we have to be aware of, and we need to be careful how we conduct ourselves, otherwise this thing will end up in court and no one will win on that basis. So I wish there was a recommendation on the table right now of some settlement of this. The one thing I think we're talking a little differently on parking spaces, because the cost of a parking space, I understand, is maybe $30,000 a piece or whatever the right number is. But that includes land and a whole lot of other costs that it's not just asphalt, you know, and that's really what we're talking about here. And so I guess the best offer I can think of at this point to resolve this issue is to bring the cost of the improvement that he did, we didn't get, I guess, down to a number that's acceptable, that we can then find a way to mitigate that money. And so I guess I would suggest that if it was 3 parking places that are in question, I guess, as I recall. I just I don't know, I would say some lesser number would be certainly worth considering so that we could put this thing to bed, or at least, I guess is this gonna be, go to the board, or are we into the road on this?
I mean, you have the, option of acting on the appeal. You can deny the appeal is one option. Then of course the appellant can, appeal that up to the board. You can also, provide direction for us to go back and work with the appellant on some sort of compromise based on some direction, because we would have to come back, present what that is and have, findings associated with that, that agreement or approval.
Well, at this point, the only soft area that I can find is just simply the cost on a square foot basis of doing the parking area. And I think some other number might be appropriate there. Because I'm familiar with parking stuff like that. And I think that we, if there's room enough to negotiate a settlement and put it to bed, that's great. If it's just impossible and there's no middle ground, and I guess at some point here we need to ask Gary to comment on this, if he's willing to try to negotiate a number with staff. I guess that would be the easy way out of this. I'm not trying to punish the staff or the applicant or anybody. I just like to find a ground that's reasonable that can put this to bed and move on. I don't think Gary does a lot of good stuff in the community, and I hate to lose that resource over something like a parking space, or two. And so if we can find a way to satisfy that need, and it may be that there's staff can come up with a work program that would be a benefit to the community that's worthwhile, and the staff and the board can agree on it. Maybe it'd be a little less painful for resolving the issue.
Okay, so let's see if there's any more discussion.
I would like to agree with the last speaker, and I was going to comment on it anyway. I am very uncomfortable with this in lieu process. It's too vague. I mean, it's really hard to nail down, and I really would object in the future unless we got some really tight parameters around offsetting any fees or any obligation in lieu, because you have these kind of situations come up. So I just think we should stay far away from this. And I'm not speaking to the past, but I'm also speaking to the future, because he's also suggesting that maybe something could be done in the future, and I think that's a bad idea. So I just want to make that point very clear. And again, I'm speaking for myself personally. This is what I feel. And I guess, obviously there is a shortcoming on the side of the county, but I believe an obligation is an obligation. There was an understanding of a number at the time, and again, I wish the vagueness of this in lieu had never been surfaced at the time, and the obligation has not, in my mind, been resolved because we don't have the documentation to prove that. So that's my position at this point.
If I might, a couple things. One, I think, correct me if I'm wrong, counsel, at this point with respect to this very specific issue, that what was the previous findings was that the in lieu was part of it. In other words, we cannot at this point reduce that to Wayne's point. Is that right? In other words, we can't sit here today and say the in lieu is not applicable, irrespective of how we feel personally about that.
If you wanted to, the council could choose to direct staff to go establish findings and to come back with a revised condition, but there would need to be findings that would support that revision based on what's previously in the record.
And then, Gary, if you might, I think Fred was are proposing some kind of financial compromise. Is that correct, Fred?
What's the question now?
Oh, I think Mr. Severson was proposing some kind of, Larry, sorry, proposing some kind of financial compromise as a suggestion. Is that right? Something less than 30,000. That's the sense I was getting.
Yeah, I would suggest that we try to get our arms around the exact cost to replace 3 parking places in some location, whether it's in town or whether it's a mitigation fee or just how that gets resolved. I think there is most likely some room for adjusting it down, I guess, because I think you could pay 3 parking places for a lot less than $30,000, and I guess that's the point of it.
Right.
So you only have land costs and other
Right.
permit costs, why it could be a different number, I guess, is what I'm looking at.
Well, with that in mind, Gary, I guess my question to you, if you don't mind coming up to the podium again, would be, would you be willing to engage in some compromise financial negotiation, leaving out the in lieu? In other words, if there was some opportunity for financial consideration less than the existing $30,000, would you have an interest in potentially paying that? What might that be?
I think so. I'd kind of like to hear from the other 2 planning commissioners on what their opinion is, and then I think we can talk about something of that nature.
Okay.
My opinion is, first of all, the request was to eliminate the condition number 4, which includes that in lieu stuff. So if we deny this request, basically that bill's on the table according to the city of, county house. It's a live in city of Roseland, sorry. But we already went that route, sort of, in the sense that this agreement was already reduced from the 45,000 down to 30, which we don't even have documentation on that.
We do.
We do. We do on that one. Okay, so it is 30. And but we have no documentation on going from the 30 down to doing some design work for the county. So I have a problem with not denying this. I think I'm going to deny it. I'm open to Larry's suggestion, Harold's here, but negotiate some lesser amount. But I really think we can't just eliminate number.
Can I just add to that? I think we might be talking about 2 different things.
What did you say? I'm sorry.
I think we're talking about 2 different things when you say about the in lieu. The in lieu is codified, is written as part of the original variance.
That's right.
That is there.
That's right.
And there was nothing subsequent to that. There's nothing in writing that says the design site review approved it. So there are 2 different things we're talking about. It is written down as part of the original variance.
There's no indication that's fine.
But yes, that's correct. That's the difference.
Richard, yeah, please. No, he's asked for all of us to speak, so
What's that?
it's your turn.
Oh, well, yeah, I do have a question because you made the statement that the county went ahead and built the bus stop. And you also indicated that they used your permit, you that?
I supplied the county with all permits.
Huh?
Yes, I supplied the county, Brad from engineering, with all the permits that he needed to go forward with that bus shelter. And they did use a couple of our design ideas from our plans, yes.
There's some here, public works.
Yeah, I guess I didn't hear that real well, but maybe.
I
Yes,
can't confirm that he used, or that the county used the permit that he obtained.
You say you can?
I cannot confirm that. I'm not sure. I did look at it.
He'd have to check, I'm sure, back with Brad and what actuals went forward. But yes, we did give them all the approved signed permits to Brad at engineering.
So if the county used your permit that you had submitted, us, would that be acknowledgement of Been moved? That's the question.
Well, he opens
Well,
it.
let's let,
If the county were to find evidence suggesting that those plans were submitted and approved and there were permits issued for it, that's not evidence that the commission can consider at this point. So the council or the commission would need to provide direction back to staff to further look into that and bring it back. It would need to become part of the findings and part of the record. But at this time, it appears that we don't have such evidence in the record.
One more thing, is there any provision, with respect to these type of payments for interest to accrue? Or in here, so. Is there any interest provision?
That's not part of the current condition as written.
Gary, was the money used to pay for that permit, was that money that was raised in the community, or was that actually out of your pocket?
Out of my pocket. And we have the receipts, which the county has in their file, the receipts for all those permits, as well as the signed permits. They have all those.
How much money did you actually raise for the actual structure?
Well, we had 60,000 from the North Lake Tahoe Resort Association, and then we had the remaining 90,000 in-kind services and donated goods, which didn't get perfected because the project never went forward.
Well, were there any hard dollars put up?
No, other than my design fees, there were no hard dollars put up in our permit fees.
Just like to make one final comment. I find it extremely troubling that we have a $30,000 obligation, and then we proceeded to satisfy that obligation with some other work that has no documentation. Or, yeah, no documentation.
Well, when you say documentation, the hours put in are.
No, not your
Okay.
documentation. I didn't mean your documentation. I meant that was some kind of an agreement that item number 14 or, condition 4 was being satisfied through that process.
I guess you could ask staff if they would have had that up front, if they would have approved that.
I mean, I think the real issue here is, it wasn't until, 9 years after this variance approved did this, even come about, even later than that. When this project that he's talking about came about, Mr. Davis did not come to the county to fulfill this condition of this variance. It was a separate project. It wasn't a matter of coming to the county and asking the county that, hey, I have this idea, this is a project, this is how I would like to satisfy this condition. Is this acceptable to the county? There's no documentation whatsoever, as far as I know, Gary, that was your intention. Not until there was a complaint filed that this condition was not met did this bus shelter idea even come up. So that's one of our concerns. Going beyond that, just jump into the condition. The condition does require an in lieu fee, but it says as an alternative, there may be a contribution of land, transit facilities, or off-site parking. So there's other options. Up until a week before this hearing, we were having conversations with Mr. Davis to see if we can come up with some sort of compliance with this condition. We talked about a recordable reciprocal parking agreement with the adjacent property for the 3 properties. In turn, over the weekend, Mr. Davis sent us a letter from the property owner, not signed, but a letter that said they had an agreement. Well, that's not a recordable reciprocal parking agreement. If we could get that, that's something the commission could consider as far as meeting that condition if there's adequate parking, even though during those, the issues during those few summer months when the rafting season is going strong, is there still adequate parking? So, maybe there is for 2 of the spaces or 1 of the spaces, but then they would have to, maybe there's a reduced fee. We had some good discussion, I thought, up until last week, trying to come up with something, but, we're here today without anything, without the appellant coming up with another solution. So, a recordable reciprocal parking agreement with adjacent property, I think that's, if Mr. Davis can show that he can obtain that, I think that would go a long way in meeting this condition.
that really wouldn't have anything to do with it.
Well, the issue is there's existing uses on those adjacent properties, and when it is rafting season, my understanding from staff is that there is a parking shortage. So, should there be some compensation for, those 2 or 3 months out of the year, maybe it's a prorated fee because they aren't able to provide all 3 parking spaces 12 months out of the year, maybe that is something that could be considered.
But that would be part of the agreement, or
No, so the in lieu fee portion of that would be part of this discussion here at the commission and, direction by the commission on crafting some language to that. But he would, have to come up with that reciprocal parking agreement with adjacent property. I'm not sure if that's something that you can do or not, but that may be one option.
And I can address that because I know their parking needs in the summertime. When they do have rafting on, they need every parking space they can get. And there's no way I would ask them to obligate 3 parking spaces during rafting season. For them to obligate it with a reciprocal easement that goes on into eternity would not be in their best interest in any form or fashion because it's going to devalue their property somewhere in the future going forward. They're going to have that issue to deal with. We have a gentleman's agreement, and that's what it's going to remain with us, to use that property for the 10 months out of the year that we're able to use that property. So if you were to look at the fees and say, what I would think might be a fair way to solve this is take a look at the 2 months out of the year we don't have those 3 parking spaces and prorate the 30,000 with that in mind. That would be a fair resolve, and I'd still be willing to do more toward donating other services to the county, but I understand the difficulty that Mr. Nader has with that. And unless you got a contract that really specified that going forward very clearly with the county, I can see there is a lot of vagueness in there, and it's kind of almost a handshake agreement that somebody has to agree to in the future versus having a solid agreement in the front end, which obviously the county and I did not have. So a lot of it's based on integrity and trust, which I think we have always had with staff of the county and other members of the county. And so that's where we are today. If we were to prorate, again, the 2 months of the year that I don't have 3 spaces, I would feel that's a fair economic gesture.
still takes some portable parking.
Yeah,
Correct.
That's correct, yes.
okay.
Okay, so-
We're not gonna go there, so we're not gonna get that.
I think to me, it seems like the basic issue is to find parking. I guess the bus station was an idea, I guess, is application, basic issue for parking. Back to that issue. Cost, parking.
Well, this whole situation is regrettable, especially over a period of time. Lots of days and things involved. But based on the evidence before us, I'm inclined to support staff tonight. So that's kind of where I stand.
Well, I'll make a motion, and for discussion, that we deny the appeal filed by Gary Davis, oppose the zoning administrator decision to deny variance modifications supported by the findings stated in the staff report, and direct staff to work on finding a resolution to condition number 4.
Is that,
Yeah, let's take these one,
one at a time.
one at a time. Thank you.
Deny the appeal filed by Gary Davis.
okay.
Okay, is there any further discussion?
Yeah, I don't necessarily agree with the motion. I think that there's a lot of room and a lot of aspects of this problem that could be resolved without just simply denying it, and because you still don't have any more parking and you don't have any mitigation, and it's going to go from here to probably to the Board of Supervisors, and then from there to some court somewhere, and nothing will improve in the process. And so I think there's room for negotiation if there's a willingness to do it by the parties involved, the staff and and a development issue, to somehow resolve it. I'm very sorry that we've become so litigious now that we can't have agreements with handshakes or verbal, because it's just not the way we can do business anymore. And I think we found ourselves in a trap as a result of that. And I just wish there was some middle ground that the staff and Gary could sit down and come to terms on and put this to bed, rather than the attorney. No offense.
Let me ask a question.
The attorneys are going to get all the money.
Okay, so I was hearing that there's two options. One, deny. I guess. And of course, that's going to require us to go through and deal with.
That wouldn't be an elimination of the condition. It would not be elimination of the condition, but it would be directing staff to come back with additional information.
That would be option two?
Yes.
Okay. So it wouldn't require a denial.
But you do. The request from the applicant is to eliminate condition number 4. And if you're in agreement with that, fine. If not, then deny it. And then the second part of my motion, that's why it says uphold the administrator, but also to direct staff to, I'm going to try to make it all in one, so they could negotiate either lower price or in lieu fee or design work or whatever they came up with.
So that's a question I'm asking you, counsel. I want to find out, counsel, your answer.
So you would either be taking staff's recommendation and denying the appeal, or you would be continuing this and directing staff to bring this item to at a later date planning commission meeting with new findings based on the commission's direction, and that could potentially include a modification of condition number 4 based on those findings, but the direction would need to be provided to staff on what the commission desires.
Okay, well, I mean, in my ideal world,
Okay, thank you, Carol.
would like some compromise to occur here. I agree with that we talked about. Probably seems like a minor issue, but there are implications for the county at large. I'm just wondering if we could table this, direct staff to continue negotiations with Mr. Davis, but set a relatively short deadline for resolution. In other words, I don't think this thing needs to drag on. It's for another 10, 15 years or whatever. So my inclination would be to say, let's table this for the next meeting, and in the interim, have staff continue negotiations with Mr. Davis, and if cannot come to a resolution, bring it back to a vote. Planning commission.
It seems like we have at least two that are in favor of that, I guess. So what I was hearing is, what would the direction be, staff?
Correct, you need to provide direction to staff on what you would like them to look into.
Yeah, one thing to consider, if there's not appear to be an opportunity for a reciprocal parking agreement that can be recorded, that really limits you to a straight in lieu fee of some value.
Financial.
Yes,
Right.
or one of the options of contributing land or transit facilities or off-site parking, which here we are 15 years into this, the timing on something like that, there would have to be some sort of mechanism to see something done, and it's
Right.
something you need to consider.
I'm very interested in deadlines and timing. That's something very, very specific. Unfortunately, done, it seemed kind of ended, even to the extent some future in lieu work. It should be specifically tied to a project, very specific
Okay,
deadline.
let me, at this point, before we distract you, I think we have a motion. Second. Is that correct?
Now, what's the process? I haven't done this before. Can I withdraw my motion?
Yes, you can withdraw your motion.
I withdraw my motion. I'd like to make another motion to continue this to a future date specific, and direct staff to satisfy that condition through either the negotiated amount of money for parking space or parking spaces someplace else or any other option that they come up with that to bring it back to us in December. Is that enough time?
Yeah, December 14th is the next meeting, and it would be up to the commission whether they want to hold that meeting in Auburn or up here in Tahoe.
No one.
We wish.
Well, when can we, I asked them, when could we have, or I'm getting back to Merrill's, trying to set a deadline?
Well, for staff to come back to the commission with, after meeting with Mr. Davis, I think December 14th would allow adequate time for us to at least see if we can come to some agreement. At 10:05 on December 14th, if that's what.
Yeah, that's my motion, and continue in December 15th, 10:05.
And it would be supported with the staff report.
Absolutely, absolutely.
I'll second the motion.
Any further discussion? They give you that direction? Yes, son?
I think so. I think we're clear. You know, when I outlined what the options are, either, you know, a different or prorated in lieu fee in lack of a reciprocal parking agreement, or one of the three options with specific timing mechanisms and projects associated with those as well. So I think I understand that.
Great.
Okay, well, thank you. Go ahead.
We have a motion by Mr. Rokucci and a second by Mr. Sedison. So, Mr. Haber.
Yes.
Mr. Rokucci.
Yes.
Mr. Nader.
No.
Mr. Sedison.
Yes.
Mr. Johnson.
Yes.
Okay, well, thank you. And should we take 2 minutes?
Couple of minutes.
Get a cup of coffee, then we'll start our next presentation.
This is a regional vicinity mapping project. We see the project site right here. This small remote portion of the property is part of the same property and technically is part of the project site, but nothing would happen on this property. It's zoned open space and would remain that way. The property is located about 3 miles to the southwest of the intersection of Alpine Meadows Road and State Route 89 out here. To the northeast here, or northwest rather, we have Grant Chief Wilderness, Squaw Valley over the ridge. To the south is the Alpine Meadows Ski Resort. And then immediately adjacent to the project, this is the Bear Creek Association subdivision, Alpine Estates subdivision, and then surrounding the project site over here is the chalet condominiums. This is a little close-up view of the project. Again, Alpine Meadows Road coming along here, providing the single point of access into the project. This is the Alpine Condominiums, Stanford Chalet project, which you all heard, I think, about a year ago over here. Bear Creek Association, Alpine Estates. Before I get to this, so wanted to provide you all just a little bit of a roadmap for this project. So the draft EIR includes a project level analysis of 2 project alternatives. Those alternatives, Alternative A and Alternative B, are evaluated at a co-equal level, meaning that we have done a project analysis on both of these alternatives. Alternative A is the applicant's originally proposed project consisting of 47 primary dwelling units and 5 secondary dwelling units. And Alternative B is a somewhat environmentally constrained, reduced density version of the same project that would construct 38 primary dwelling units and 5 secondary dwelling units. Alternative B was developed in coordination with the county staff to address issues that we raised to the applicant early on in the project review, as well as comments that were received during the notice of preparation scoping period. So with that, this is the Alternative A tentative map. It consists of 27 lots 1 through 27 over here, executive, that are targeted for executive style custom homes on lots ranging from about 4/10 of an acre to 1 acre. In the western portion of the project, we have a total of 20 units consisting of 14 halfplex units that would be split along a common property boundary here, and then 6 cabin site lots. An on-site private roadway would provide access. and it is located about 150 yards to the north of the Chalet Road, which is down here, and the beginning of the Alpine Meadows Ski Resort parking lots. And obviously would continue through the project site. As I mentioned, it is the single point of access. Construction of on-site private roadways would include a total of 5 bridges. There's a bridge here over Bear Creek, and then there would be a total of 4 bridges over an unnamed seasonal drainage in the eastern portion of the project area, and crossings of some ephemeral drainages in this area. In addition to on-site roads, Alternative A would also construct on-site utilities, including a sewer lift station located in the northeastern portion of the project on Lot H. And then on Lot I here is an HOA maintenance facility that would also include an HOA meeting room and a small caretaker's dwelling unit. This is just an illustrative of the same plan showing kind of conceptual configurations of homes and building envelopes. Alternative A would include approximately 14.2 acres of open space common area. Those parcels would be held in common by the HOA. That would be an increase of about 4.3 acres over the existing zoning designations. So this is the alternative B tentative map that I mentioned. This is the reduced density version of the project. It consists of lots 1 through 28 in the eastern portion here, again, those executive style custom homes over in this area. And then the main difference is the western development pod in this area. The half-plex units were eliminated in favor of 10 cabin lots. So the lot sizes over here are comparable to the Alternative A project, and then over here they're also comparable to the Alternative A project cabin sites, and then of course where the half-plexes were eliminated, those sites are a little bit bigger, and importantly, we don't have development over in this area. This was an area of steeply sloping lot area. As with Alternative A, the on-site private road would connect to Alpine Meadows Road just north of the entrance to the Alpine Meadows Ski Resort, and they would also construct the same number of bridge crossings. So overall, Alternative B proposes 9 fewer residential units, but would include the same number of secondary dwelling units. Both alternatives would have similar development footprints. However, Alternative B would include just under 19 acres of open space, and I'll show you a zoning map shortly, but that's owing to incorporation of more open space area over in here into the open space zoning designation. Some other differences with Alternative B, there were a number of lots, particularly in this area of the development and this area of the development, that had slopes on portions of the lot that were in excess of 30%. The county has a general plan policy that prohibits development on slopes in excess of 30%. So the Alternative B project would be constrained to those areas that are 30% slopes or less. Another difference, and I'll get to this a little bit later, we don't see it here on this plan, but the HOA maintenance facility has been moved from this area to this area and would include a lodge that would also function as, again, a caretaker dwelling unit, would have some HOA amenities associated with it, which I'll later describe, and then would also function as a shelter-in-place location during emergencies. I'm going to go back to this for just a moment. So as described in the EIR, the applicant has prepared an emergency preparedness and evacuation plan. The genesis of that came out of some of the planning, I think, that we were doing for the village at Squaw Valley Specific Plan, as well as the Martis project at the same time. And that was coordinated with the North Tahoe Fire Protection District. As I mentioned, this in the event of an emergency scenario, residents would have an opportunity, first of all, to be able to shelter within the residences, which would be constructed to Chapter 7A code requirements that do have some extensive discussions with Chief Schwartz of the North Tahoe Fire Protection District about the feasibility of that. Preferably, the project residents would evacuate out during an emergency. This would be a last best option. but ultimately residents would be able to evacuate to that lodge and then eventually evacuate out of the project. So this is this zoning exhibit shows on the left here the existing zoning of the project area. Where the roadway comes in is open space. You see in the middle of the project area where the roadway would pass over to get to these other residential areas is also zoned open space. And then we have a couple of different residential zonings here, all consisting of residential single-family zoning consisting of minimum building site of 20,000 square feet in this area, and then with a planned unit density factor of 2 here, 4 here, and 4 in this area. This is the proposed zoning for the Alternative A project, which, as I mentioned, would rezone the preponderance of this area over here, which is located in the high hazard avalanche zone, from residential single family to open space, increasing the amount of open space overall by about 4.3 acres. And then there are some other micro adjustments to incorporate other areas for residential zoning that are suitable for development because the slopes support development and because they are not located within PAHAs. This is the Alternative B rezoning exhibit, as I mentioned. It does incorporate a total of 19 acres of open space, increase of about 4 acres over the proposed project. And the main difference is the incorporation of these areas that go through the developed portion of the project over here, which include the stream resource. We wanted to get that into that open space area. So impacts we analyzed in this draft EIR, we evaluated most all resource areas. I believe the only 2 things that were scoped out were agricultural resources because there are none on the project site. And then cultural resources, we had a negative cultural resource assessment from Susan Lindstrom, the consulting archaeologist. And otherwise, it's a full scope EIR looking at all these various land use areas, which we're going to go through, and of course including cumulative impacts and alternatives. Importantly, this EIR concluded through its analysis that all impacts that were identified, we were able to find feasible mitigation measures that would reduce those impacts to a less than significant level. No residual significance with those impacts. In the area of land use, we analyzed the consistency with the project zoning. It is proposing at the Alternative A level to construct a total of, I believe it's including the caretaker unit, 53 dwelling units. On Alternative B would be 44. The overall land use holding capacity under the existing zoning is about 101 units. Then we also did a policy consistency analysis with all of the general plan policies to validate that the project would otherwise conform to the county's requirements. And the one thing that did come out of that analysis, of course, is we are in the Tahoe area and there is a shortage of employee housing. The project would have to meet its contribution towards employee housing, and so there is a mitigation measure that each phase of the project, with each recordation of each final map, the applicant will have an employee housing plan approved with the county. It'll likely include the typical mix of dedication of units, in lieu fees, dedication of land needed for units, or in this case, there's also the ability to construct a unit on site, and that will go towards a portion of meeting that employee housing need. With visual resources, this was one of the more important impact analyses that was performed for this project. There was some concern about visibility from the Five Lakes Trail, which goes up on the other side of the canyon into the Grand Chief Wilderness area, and how this project could affect views from that area, as well as from the immediately adjacent residences. Overall, views of the project site from nearby proximity is relatively filtered by existing trees and vegetation, and though there is a fuel reduction, fuel management plan associated with the project, the overall findings of the visual impact analysis were that there would still be adequate vegetation, that those views would remain more or less, I won't say substantially unchanged, but they will not be significantly adverse in their impacts. What you would see instead of an undeveloped site is you would have a slightly less dense, a somewhat less dense tree canopy, and then a view of a high quality residential project. The major finding of the analysis was that the construction impacts will probably have, in my opinion, the most significant impact because of the ground disturbance, but that's a temporary impact, and there are impacts, mitigation measures rather, that are identified through screening of stockpiles of materials and equipment storage locations during construction, revegetation of graded areas, storing stockpiles in areas that are not highly visible, and then of course retaining grade cuts as improvements are constructed. And then with the developed character of the project, there are some pretty robust architectural design guidelines that the applicant has developed that will determine things like earth tone colors for roofs, that all the exterior building materials and colors have to be noble materials like stone, natural wood, masonry products that mimic stone that will blend into the natural environment. So at the end of the day, you'll have an overall high quality visual setting. Another important thing I think that we did was that a lot of times the infrastructure improvements don't always get as much treatment as maybe they could. So we mitigated them by requiring that they be constructed of rusted steel, so the guardrails would not reflect solar glare in the daytime. Windows from buildings would be protected under recessed alcoves, things like that. Biological resources on the project site are what you would expect to find in this kind of montane setting. You have a mixture of habitats, mostly consisting of white fir forest, also with red fir, and then some riparian areas along Bear Creek, and also the unnamed seasonal drainage at the eastern portion of the project site. There are some sensitive habitats and species associated with the site. Those are primarily what you would find animals that are living in the setting, your typical animals. And then as far as sensitive species, we've got yellow warbler and pallid bat. And there are mitigation measures that are built in through the project's implementation for avoiding the 100-year floodplain with the construction of bridges, receiving permits from CDFW for any impacts in the waterway, which these are span bridges. They're meant to avoid as much of the habitat as possible. Permits with the Corps of Engineers and the Regional Water Quality Control Board. And then of course buying mitigation credits for any wetlands impacts. There may be some very small wetlands impacts associated with those ephemeral drainages. And then of course doing sensitive species surveys pre-construction and making sure that those issues are treated. With regard to transportation and circulation impacts, the overall increased volume of traffic at area roadways and intersections was found not to have an impact. However, we did find that there are some impacts potentially associated with project construction that we wanted to make sure that the ability of emergency responders to gain access to the site, to gain access to neighboring properties would not be impeded. And so there will be a construction traffic management plan. And also a requirement to obtain a service agreement from the North Tahoe Fire Protection District and the Alpine Springs Community Water District. Importantly, the fire services are actually contracted by Alpine Springs to North Tahoe Fire, and so they have a role in that. With respect to project noise, it's a low-density residential subdivision. The operational character of the subdivision is such that it was found not to result in adverse noise impacts to its neighbors, either by virtue of its operation or the traffic coming and going on the adjoining roads or through the subdivision. We did do noise modeling for that and had predictive results that included 20 years of traffic growth that were modeled into that. One finding on noise was that construction noise, obviously short duration, there would be an impact because of the earth moving equipment, and that compliance with the county's noise ordinance, which limits days and hours of construction, would address that issue. With respect to air quality impacts and greenhouse gas emissions, all impact criteria were found to be below thresholds of significance, and so in both resource areas, those impacts were determined to be less than significant. Geology and soils, and then the next impact area that I'll go over, hydrology and water quality kind of play together quite a bit because they have a lot to do with the project's construction and then of course its operation. So overall, the finding again was that all impacts could be mitigated to less than significant through things like our standard construction processes. The applicant's going to prepare a final geotechnical report that's going to have the engineer's recommendations on how to do all the soil stabilization, That's going to be reflected in the improvement plans, both with short-term and long-term improvements. They're going to identify stockpile locations on improvement plans, implement a dust control plan and an erosion control plan for any of those stockpile locations and during project construction. That's the temporary and permanent stormwater quality treatment facilities. And there will be a requirement to receive approval from the Regional Water Quality Control Board prior to construction. And so a lot of that's repeated here in hydrology and water quality. I won't go through it all, but effectively the project will have to have temporary surface stormwater quality controls in place during construction. And as is the case with all modern subdivision projects, they have some pretty substantial requirements. I would say that the water quality treatment facilities are one of the most significant planning efforts and engineering efforts that go into modern development. They'll have a lot of structural control features that are LID features that are built into the project residences. And that's to ensure that all stormwater discharges are treated and are cleaned before they're discharged into any surface waterways and leave the project site. There are also requirements to limit snow storage on the project on-site roadways so that any snow melt, because when you remove snow, oftentimes there are things that come up in the pavement, grease oils, sands, whatnot, that have to enter stormwater quality treatment facilities before they discharge. So there will be limitations on the snow storage areas such that they can't be discharged directly without going through facilities. And then lastly, I did mention earlier, the bridges, all of the bridges that are proposed avoid construction within any portion of the local 100-year floodplain. There is no FEMA 100-year floodplain on this project. It's just a local county designation. With respects to hazards and hazardous materials, I apologize, I butchered this a little bit earlier, so I'm gonna go through it in just a little more succinct detail. But so we worked with the North Tahoe Fire Protection District and Alpine Springs Community Water District to develop this emergency preparedness and evacuation plan. It works hand in hand with Alpine Springs evacuation plans that are part of North Tahoe Fire Protection plans that are part of the county's East Side Operational Evacuation Plan. And ultimately, because this project does have a single point of access, it was felt very strongly on the part of county staff that something more had to be done. There is no ability to provide a second access to this project site, unfortunately, due to ownership constraints that surround it. The applicant spent a long time negotiating with the Bear Creek Association for an alternative access point, secondary access, that was ultimately not fruitful. They've also negotiated with the Forest Service. The Forest Service does not grant easements for private development unless there is absolutely no other access, and they do have access. And so we felt strongly that we had to come up with something else, and that's where this idea of this HOA lodge that would have an amenity to the project. It's a 3,000 square foot facility that would have potentially outdoor swimming pool, jacuzzi, fire pit, bocce ball court, something like that. Would also double as a last best option in an emergency evacuation event. And that facility would be constructed to a standard much like the homes. They're constructed to allow a fire to blow over. They're not a long-term shelter-in-place location, it's short-term. But in the event that there is not an opportunity to evacuate early, you need a second option. And when we get to the entitlement hearing, we'll definitely have Chief Schwartz here to speak to this. But I was surprised to hear him say that he felt that based on the emergency contingencies that have been built into this project, that it probably enjoys a higher level of emergency preparedness than other properties in the surrounding area. Some of the other things that the project is going to...
Alex?
Yes.
Yeah, on that point, I have a question with regards to say the road in there blocked off.
Yeah.
And somebody has a medical.
Yeah.
Is there going to be a place out there where it's look out?
So I'll repeat the question. So the commissioner's question was, in the event of an emergency and the access road is blocked by landslide, avalanche, fire, something like that, is there an opportunity for an alternative way to access the project site through helicopter or something like that? That's kind of an emergency preparedness, an emergency services function I'm not totally capable of answering, except for yes, there is a place that will be designated in the project. So if I just go back here real quick. Down here where there would be adequate location for a helicopter to land in that roadway and potentially evacuate people out. The project is going to be required as a mitigation measure to have snow removal equipment that it will keep on site just for that purpose. Alpine Meadows Road is in the path of a lot of avalanche slide areas, including where the project entrance is. The path is actually west of the project upslope, and then comes down and covers over the road and comes into the project a little bit where it would enter the site. And so there is a requirement to have heavy equipment on site just for that purpose. So a couple other things, and I think these are important because they speak to some of the other aspects of the utility enhancements of the project. Presently, the Alpine Springs County Water District is deficient in fire flows in 2 of its existing zones. So there is not capacity to serve this project. This project is required. They funded a study through Stantec that was managed by John Collins and his group at Alpine Springs, and it determined all the upgrades that have to be constructed to resolve those deficiencies within the existing 2 pressure zones, and then of course be able to provide the service to the project so the project would correct for that deficiency. And as I said, they would also staff and purchase and staff snow removal equipment that would be on site. And importantly, they would also implement a forest management fuel reduction plan. The forest condition on the site is degraded. There's a huge amount of fuel buildup. There's a lot of fuel on the ground. There's a lot of clusters of trees that are very choked out. And so part of the NTFPD's service requirements are that they're going to have to go in and thin that, manage it, get those fuels off the ground, get the ladder fuels out there, break up the continuity of the crown so that you don't have, as much higher potential for crown fires. And these things, again, kind of lead into the analysis of public services and utilities, so I won't go through that. I already did. Fund your fair share contributions to the Alpine Springs water system. And then again, prepare and implement that construction traffic management plan during the project's implementation. Cumulative impacts for the project were few. They would be reduced to less than significant by payment of traffic mitigation fees for the overall network improvements that are included in the county's CIP for its planned network enhancements. Those would be due with the each building permit. And then for alternative modes of transportation, establish a zone of benefit to fund their fair share of transit services for the greater Truckee, North Lake Tahoe area. So with that, as I mentioned, we are within the draft EIR circulation period. It ends next Friday, November 3rd. Verbal comments may be submitted today at this hearing. You may submit written comments at any time up to November 3rd at 5 p.m. There will be future opportunities for public comment on this project in addition to today's hearing. There will be a North Tahoe Regional Advisory Council meeting to provide as an action item for the NITRAC to provide a recommendation to your commission. The Planning Commission will ultimately hear the entitlements probably in several months from now, and you folks will make a recommendation on the package of this project proposal that will be forwarded on to the Board of Supervisors for their ultimate consideration. I'll just leave this screen up here about where to submit comments. Obviously, I'm here to answer any questions you may have. Also have Phil Franz with Engineering and Surveying here today. We have Catherine Waugh with Dudek Environmental, our environmental consultant. She's recording all of the comments. And also have Chris Nelson, project proponent, and Doug Clyde, who is also working for Chris on the project. This time, if it pleases your commission, I'd like to invite Chris up to just offer a few comments on his planning efforts for the project. Yeah.
Thank you, Alex, and Planning Commission Chair and members.
I'm going to keep my comments very brief, but I just thought for a little bit of context, we're coming up on the 20th anniversary of owning this property. We acquired it in December, almost 20 years ago. And coming out of the recession, or during the recession, we decided to make the investment in doing the full-blown EIR versus trying to pursue a mitigated neg deck. And Alex walked through at a high level summary of all the environmental impacts. We spent several $100,000 on studies to hopefully get to a point of understanding all the impacts and how we can mitigate those. Property's owned by 3 couples, and we've started with a much higher density project and have worked over several years, most recently since about 2010. We've done a lot of outreach to all the adjoining subdivisions. We've been to NAPRAC now 3 times at least, Alpine Springs Water County District multiple times. And so I guess I just wanted to make the point that we've tried to be transparent in our outreach and give everybody the opportunity to have input on the project. Before doing the most recent effort in land planning, we did study a much higher density development. The zoning technically could get to over 100 units. That wouldn't be practical, but we did study a higher density lodge on the upper portion of the property, which now has 10 cabin lots, which are pretty similar in size lot-wise to the adjoining subdivisions. We ruled that out, both for market considerations as well as just felt that that was too dense. We looked at a much more dense townhome development with a big cluster of townhomes in the area that are now the larger estate lots, as well as in the cabin lots that got to about 65. We came in with an initial plan that was 47 units, and through the process of working with the staff, getting feedback from different neighborhood groups, have landed on this option B, which we feel is an appropriate project. So I'll just leave it at that for now, and appreciate your consideration.
Okay, thank you. See, this time I'd like to open it up for comments. Planning commissioners, we can talk. Okay.
Hi.
What's your name?
I'm Melissa Sig. I'm a 13-year resident of Alpine Meadows, and I have a few concerns about this project. Whether they're going with alternative A or B, 40 to 50 homes in Alpine is a lot of homes. The construction of these homes will impact residents for years. This is not a minor impact, this is a huge impact. I live on the main road. There will be trucks going past my house constantly for years, so that's a major concern. Another concern I have is that, as everyone knows, we have a housing crisis in this area, and building more second homes does nothing to contribute to resolving our housing crisis. These, I'm sure, will be second homes that will be occupied a few times a year. Already Alpine Meadows is probably occupied, it's probably 80% second homes. So I worry we're once again building trophy homes for people who won't live here. So if this project builds one house for employee housing, that does nothing to resolve the larger issue. We don't need more second homes in Alpine or Tahoe. A third issue I have is I would like you, I know you're not required to look at this as at cumulative impacts, but I would encourage you to do so. Already we have 2 major projects approved in this area. One your board approved. We have the Squaw Valley project, that development just over the ridge. I know it's tied up in lawsuits, but that is 25 years of construction, okay? We have the Martis Valley West project, which I know you didn't approve, but the Board of Supervisors did. That is decades and decades of construction. I would like you to look at this cumulatively when you have all this building of all these homes that are all intended for second homeowners. These are huge impacts to our region, and they all tie in together. I do worry about the noise. This is Alpine Meadows is a valley. I can hear everything going on in the upper half of the valley. I also am deeply concerned. I applaud any of the housing that's being located near the ski area, directly close to it near the chalet. I think that is needed. But I'm deeply concerned about the long road that will go through the forest on the trails just to connect the few other homes. I know this is private land, but I know a lot of Alpine residents use those trails to
to access the Forest Service trails. It's a beautiful area back there. I'm really concerned about that road, just destroying that area just to connect these two parts of the project. Thank you.
Okay, thank you. Okay, next.
Hi, my name is Judy Bruner. I've been a homeowner in Alpine Meadows for approximately 18 years. I'll focus my comments on several issues that I see in the draft EIR. First, in terms of traffic, the draft EIR analysis relies primarily on one-day traffic surveys to develop the modeling. For winter traffic, the date was Sunday, March 11th, 2012, on which the analysis said the peak morning traffic was 10:45 to 11:45 a.m. Using data from only 1 year and an extremely low snowfall year is unacceptable analysis. In addition, the draft EIR fails to address the proposed White Wolf project directly across Alpine Meadows Road. In addition, the draft EIR fails to address the cumulative traffic impact on the north and southbound Highway 89 traffic and the resulting impact on emergency response times. Turning to biology and a few other areas, the biologic survey report says the special status yellow warbler was observed at the site. Because of this, the report concludes that before any tree removal or mechanized equipment operation of any kind can be done, surveys must be conducted to determine that there are no nests within 100 feet of the site, and this is true from May 15th through August 15th. The report also states no grading, brush clearing, or tree removal may occur during May 1st through August 15th if any nests of smaller migratory birds are found to be present. These mitigations dramatically reduce the construction period. These types of restrictions, while frankly not enough to protect these species, further lengthen what will likely be a 15 to 20-year project, which then causes many other significant impacts in terms of noise, air quality, disturbance to other wildlife, and visual impact. And these have not been adequately addressed in the draft EIR. This construction period is not a temporary period as described. Turning to fire safety, the draft EIR states, and this is a quote, "The county zoning ordinance requires at least 2 vehicle entry-exit points unless otherwise determined by the County Planning Commission." So I guess the County Planning Commission is deciding to determine that that's not required, that the zoning is not required. Only one access road is currently contemplated in the project site, and because a second access site is deemed not feasible, other mitigations have been put in place. The draft EIR proposes a 2-part mitigation: to build the buildings with fire-resistant materials and the shelter-in-place HOA facilities that you heard about today. In the event of a large forest fire, the fire-resistant building materials and a shelter-in-place facility will not prevent the loss of life. Even if it was feasible to have 2 vehicle entry-exit points to the Alpine Sierra development, the hazard situation is further increased by the 1 entry and exit into the Alpine Meadows Valley. Adding further development to this high-risk area will significantly increase the risk that evacuation will not be successful in the event of a large forest fire, dramatically increasing the risk for existing residents who don't, by the way, have a shelter-in-place HOA facility. Cumulative impacts, and this is my last area. The draft EIR lists 10 projects on the cumulative projects list, table 15-2. Noticeably absent from this list is the proposed White Wolf subdivision, which is a proposed 74-acre development in close proximity. This is a major flaw in the cumulative impacts, and the draft EIR should be rejected and the applicant required to prepare new analysis on traffic, safety, noise, visual resource, etc. The faulty cumulative impact analysis states that the cumulative noise levels of this project and other planned projects in the area would be a significant cumulative impact. However, the proposed project would not result in a cumulatively considerable contribution to this impact. This conclusion is nonsensical. If this project does not create cumulative considerable contribution to the impact, which project does? The point of the cumulative impacts analysis is to avoid a cumulative significant impact. The report concludes, even without consideration of White Wolf, that there is a significant cumulative impact to visual resources in the vicinity. However, the draft EIR states this can be mitigated by using various building materials. Any reasonable person would have to conclude that regardless of building materials, 40 or some odd homes in Alpine Sierra and the associated roads and outbuildings will have a significant cumulative impact on the visual resources from the popular Five Lakes Trail, which is a valuable state asset and entrance to the Granite Chief Wilderness, as well as from other vantage points in Alpine Meadows. And then, of course, add the cumulative impact of the proposed homes in White Wolf, along with the lodge, parking areas, roads, and other recreation structures, and of course, the gondola. I urge the Placer County Planning Commission to revisit the draft EIR and insist upon a more meaningful assessment and more meaningful mitigations. Thank you.
Okay, thank you. Thanks.
Hi, my name is Isaac Silverman, and I'm the staff attorney for Sierra Watch. Ms. Brunner just made my job much easier because she covered a lot of excellent material in some depth. I'll keep my comments very brief. Main concerns that we have with the draft environmental impact report revolve around traffic. Unfortunately, it chose to rely on the same, for lack of a better word, fairy tale about existing traffic conditions that was used for the Village and Squaw Valley specific plan. It was relying on a lot of the same studies. They were in 2012. They're not applicable. We have a lived experience here in Alpine Meadows, in Placer County, around Squaw Valley, that we know that those traffic counts do not accurately reflect what this region experiences during times of normal snowfall, during times of normal ski resort operations. This is proposing to put an entrance to subdivision 150 feet from that parking lot that was queued up all the way to Highway 89 multiple times last year. We need to take that into consideration in our traffic analyses if we're going to be doing our job and essentially looking at what this would actually mean for traffic flow in the region. So that's around traffic. The other issue is around wildfire and emergency preparedness. There are real concerns about the ability of a shelter in place to meet the needs of Alpine Meadows residents, new or existing, in the event of a wind and wildfire. And that's just on a basic human level. I think from a technical level, on the draft EIR, it was unclear to me precisely what the threshold of significance was and what was being used to say that these mitigations would eliminate the impacts that were associated with building on and along with an 800-foot road, for example. It's not clear to me how providing people the ability to shelter in place fixes that single entry or exit problem. A last best resort, in the event of a wind-driven wildfire, being asked to shelter in place in an essentially unproven lodge rather than being able to leave, that seems like a pretty significant impact to me. And it's not clear to me how there was any threshold here to say that that was not. The final issue is somewhat related to both, and that does revolve around the proposed White Wolf development, the driveway of which would be more or less across the street from this entrance road, and that would be another 40 homes potentially, with all the same issues further compounding it. I understand that in the CEQA planning process, the standards the county used around the notice of preparation, those documents were received slightly after the initial notice of preparation moved forward for this project. So you might be able to get away with a technical, we don't have to look at this, but to really do your job as a county, to really look at what this will mean in a cumulative sense with other projects that are being proposed right now in our region, is just, to do a good job, you have to consider it. It's a basically identically sized project across the street impacting the same intersections with a lot of the same issues. So I would urge the that the county asked the project applicant to redo that cumulative impact analysis with the information that we all have right now, which is another major project being proposed right across the street. Thank you.
Okay, thank you.
Hi, and thank you for all being here. I'm Mary Coolidge. I've lived in Alpine Meadows since 1971. I bought my home in Bear Creek in 1978. So I've actually personally seen a lot of the traffic issues, and that's mostly what I'm going to talk about today. The entrance to the proposed Alpine Sierra development is pretty much directly across the street from Troy Caldwell's property, which is the White Wolf property. At the time he was building his driveway, he asked Bear Creek for a variance because he didn't have enough room to actually make that a safe entrance and exit point. It's also, the Sierra Alpine Road is right underneath the Chalet Road, which comes into the Alpine Meadows Road, and as someone else has pointed out, it's right below the parking lot. So you have an awful lot of traffic issues right there. And I don't know, it was unclear to me reading the draft EIR whether there was a plan to have a traffic light there, but having lived through the last winter anyway in Alpine Meadows, the traffic, as someone pointed out, there were days when it was backed up past Bear Creek, people trying to get in to park to ski. There's no way you could make a right-hand or a left-hand turn to get into the traffic. So again, I really think the traffic issue is a huge thing. I was going to talk about how the two studies that were pointed to in the draft EIR, one was on a day in March in 2012, which was apparently the 14th biggest day at Alpine ski area that day, but again, the hours they cited were 10:45 to 11:45. The traffic is bad from 8 a.m., I would say, till 10:30 when they're parked out, and then they're turning people around and they're trying to park them at the bottom of the hill. But again, I'm concerned with that point of entrance and exit, right off the Alpine Meadows Road, where we have snow, where we have ice, where we have people that are unfamiliar and uncaring about driving in the slippery conditions anyway. So I think that we need to do another traffic study, and a real one where you're looking at a day in February and a day in January when there are lots of cars, people trying to turn in and out. The White Wolf project was not addressed in this, and now that is used for overflow parking. The people, Troy and Sue, who own that, are parking cars there on days when Alpine Meadows parking lot is full. So there's already an additional 300 cars coming and going on a full day. You might want to look at that. I think it's, again, dangerous, hard to turn. And I was just going to point out again that the county says that there has to be at least 2 vehicle entry-exit points shall be provided or planned for. And there aren't, and I understand that it's a difficult problem. I don't know what the answer is, but having everybody try to come in on that road where there's people coming from a road across the street and one just up, I don't think it's going to work very well. And again, the cumulative effects of more houses, more traffic, whoever did the study that talked about how many cars were going to be parked, I don't think you're looking at if people are going to short-term or long-term rental their property and you're having big houses that have 6 or 8 bedrooms, you may have 6 or 8 cars for each house that's going to be built there. So you're going to have a lot more traffic and a lot more cars than have been accounted for in this. And I really think traffic is a huge issue here. Thank you.
Okay, thank you.
Hi, my name is Debbie Schneider. I live in Alpine Meadows. I first want to thank Alex for all his work he's done on this project and for keeping his lines of communication open. He's very good at responding to our emails and phone calls. A couple bullet points on emergency procedures. I am wondering if there is a population saturation point for safe evacuation of the valley, Alpine Meadows Valley. Right now, we're going to have a dramatic increase in number of cars. We're looking at the Alpine Chalet, 18 units, 36 cars minimum. Alpine Sierra Project, 38 units, 76 cars minimum. White Wolf, 38 units, 76 cars minimum. We're talking about 188 new cars on that road. And we cannot do this study based on the assumption that these will be second homeowners. These may be primary full-time residents. I also am concerned, I've read extensive studies on the on fires and the need for an ingress and an egress, specifically the Oakland fire, when was that? 1991. Thank you, close. 25 dead, 150 injured. One of the number one things they stated in the studies after that is that all new developments need an ingress and an egress. I'd like to review some type of this project being responsible for some type of valley-wide emergency alert system that is not dependent on the internet. It's not dependent on cell phones. I would reevaluate the shelter in place. I understand the same building for the shelter in place, that HOA building, is also going to be where they store 1,000 gallons of diesel fuel. Not good. I would like to have them review any change that this project may make on the fire line evaluation, which affects all our insurance rates or even the ability to get house insurance. The guarantee for that the new fire truck that's going to be purchased be stationed in the Alpine Meadows fire station and not moved someplace else and replaced with an old fire truck. The guarantee that the Alpine Meadows fire station be manned 24/7 and not that manning not be dependent on grants. The elimination in the study of all outdoor fire pits, even though I understand they'll be fueled by propane, it's not a good spot in the current conditions. No outdoor fire pits, please. A permanent restriction within the development on any on-street parking, so that if there's an emergency, people can get on that road and get out of there, hopefully. Thank you for your time.
Okay, thank you. Okay, oh, here we go.
Hi, I'm Rochelle Latimer. I'm a 46-year member of the Alpine Meadows community. I know you might not believe that, but I am. And I'm the current president of the Bear Creek Association. As you've heard, this is the subdivision adjacent to the Alpine Sierra development. I want to thank the Planning Commission for the opportunity to have public comments, and I especially like to thank Placer County staff for working with the applicant to develop alternative Plan B. And as my neighbor Debbie Schneider just mentioned, we appreciate how responsive Placer County staff and Supervisor Montgomery have been to talking with us about this plan. As members of our Valley-wide community have addressed specific areas in the draft EIR that we feel are insufficient, particularly regarding hazards and traffic, I will take this opportunity to mention a few others. In the CEQA scoping, the draft EIR asserts that there was no new information received subsequent to the 2014 notice of preparation. Yet Placer County, in fact, received formal applications and undertook administrative processing of the Village at Squaw Valley project, the Squaw Alpine Gondola project, and the White Wolf Development project. While two of those are included in the cumulative impacts, they aren't in your opening statement about this project. All of these proposals have direct or indirect impact on the Alpine Sierra development, and as all of us and homeowners in the valley too. In terms of the scoping comments, comments of significant importance to the homeowners in Alpine Meadows and to the natural resources of the area that were submitted to Placer County and appear to be ignored in the draft EIR include the traffic patterns and safety at the project access to Alpine Meadows Road, given the White Wolf development, snow removal, on-site storage, and hydrological changes to the neighboring properties. You've heard quite a bit about the emergency vehicle ingress, egress, especially during level F conditions, which we all have experienced this past year, both in the winter and in the summer. The Highway 89 intersection and Highway 89 northbound to Truckee and southbound to Tahoe City. The request for updated traffic analysis. The visual impacts to the Five Lakes Trail was identified as a significant issue by the public. As you've heard, this is one of the most popular and heavily used trails in the region, and we feel that this analysis is weak at best. Water resource impacts were identified as potentially significant in scoping comments, including groundwater recharge and impacts to the Bear Creek. Having addressed these issues by best management practices practices assertions without any actual site analysis of the adequacy of these steep slopes and large cut and fill actions is insufficient. You've heard from Judy regarding biological resources, particularly the yellow warbler. As we know that the construction in this area being limited to a very short window between August and, say, October, significantly will impact the construction time period. We also are concerned that how is it possible to do defensible space tree removal and meet the requirements of the county's tree preservation ordinance. And we are concerned about the runoff into Bear Creek associated with the likely inability to construct the project within the short construction season, and the associated impact on fish should also be analyzed. In terms of hydrology, has the county assessed whether there is adequate area and suitable slopes on each home site for the construction of effective permanent erosion control measures? If not, has the need for project level treatment of stormwater generated by individual home sites been fully evaluated? Has an evaluation been made of tree clearing for defensible space and its impact on earlier melting of snowpack and consequential increase in stormwater runoff, and how this may impact the floodplains along the Truckee River? Does the Lahontan Regional Water Quality Board agree with the county assessment of the potential impacts and the mitigation measures? Do they recommend more study? And has the county evaluated whether they have adequate resources to ensure that the mitigation measures are being provided in a timely manner? So that's it. Thank you again for your time.
Okay, thank you.
Hello, my name is Bob Tetro. I'm a resident of Bear Creek. I'd like to move the slide presentation back to a map for some of my comments. But and this might seem a little scattershot. I first began and became involved in EIRs 40 years ago with Rear 2. I'm an engineer. So I've got some piecemeal things to say about the process. It was a very complete process. Things that I saw with the Forest Service Rear 2 evaluations for roadless areas were considerably smaller in scope. And this was for large wilderness areas like Mount Shasta. But by that same token, when you break up a study into numerous subjects, such as geology and hydrology and wildlife, I think there have been some examples in this particular study where things were missed. And this is a key point that I'm going to bring up. With respect to the access road, which is visible where those thick grove of trees are on the map, that boundary line that runs at 45 degrees from lower left to upper right is the Bear Creek boundary line. That white portion off the map is Bear Creek proper. And I can stand at my house and throw rocks and hit that boundary line. So John Scott Trail is downhill from the access road, and that's a full standard county road. Am I correct? Right, to 24 feet plus cuts and retaining walls. So this is a substantial snow removal problem. It's not going to get blown uphill. It's too big and wide, and the retaining walls are going to be too high. So it's all going to go downhill. Now, you may think that there is sufficient accumulation zone in that green belt, but in fact it's quite steep. And in the avalanche study done by Larry Haywood, he identifies a major, he in fact I think tried to enlarge what he thought was the earlier Paha as being actually larger than the earlier study. And that is where all those trees are. I'm going to walk over here. This portion right here. So The snow removal efforts are going to basically load Bear Creek's property. And John Scott Trail is barely 1.5 cars wide. It's in the wintertime, it's a one-way downhill, and which this is a fact, this entire fact of John Scott Trail is not mentioned at all in the study. During avalanche control conditions, or when, let's say, the Five Lakes Ridge avalanches and closes the Alpine Meadows Road, John Scott Trail is the only upper valley exit. Nobody is allowed to go out on the Alpine Meadows Road. They have to go out on John Scott Trail. So when snow removal efforts for this access road inevitably overload the snow removal efforts of Bear Creek Association, we have a loss of egress for the entire upper valley area. John Scott Trail is a vital artery during adverse conditions, and this snow removal process completely ignored in the EIR. So I urge that this be made, refocus your efforts on this. Avalanche study was done, didn't mention the loading on Bear Creek. This is not a flaw, this is a feature of the piecemeal studies that have been integrated by a staff that is arguably juggling many balls, and they miss them. And it's not a reflection on a lack of competence in any way, shape, or form. But nonetheless, this extensive property with a fairly simple-looking access road, and even some, as I read it in the EIR, 35-mile-an-hour speed limits along that access road. It amounts to a huge volume of snow encompassed by a slope that's cut to allow a 24-foot road, and all that snow gets pushed off downhill, and it goes into Bear Creek and lands on John Scott Trail. I cannot see that snow going anywhere else. The other issue I want to bring up is has been touched on by some other people, and that is the fire station. It states in the EIR that that's the Alpine Springs County Water District Fire Station at the bottom of the Alpine Meadows Road is staffed 24/7, and it's not. It is staffed on an ad hoc basis as much as possible, but in no way, shape, or form is it 24/7. And those staffing levels are established by grants that have to be constantly renewed. And I don't know the provenance of the grants, but what we are looking at in from a 50,000-foot elevation, when we pull back and look at the view of fire safety in Alpine Meadows and Squaw Valley, when Alpine Meadows is not staffed, all emergency response vehicles come from Squaw Valley. And we are looking at an antiquated and band-aided fire protection scheme that is the best that North Tahoe Fire Protection District can do, but it is nonetheless woefully inadequate to what we have seen is more and more going to be the norm in California. The Santa Rosa fire, the King fire, the Oakland Hills fire overpowered the existing fire protection schemes, and we very easily could face that kind of a reality in the overburdened, fuel-rich environment that we're living with here in Tahoe. So the mitigation measure against the one entrance exit problem onto the Alpine Meadows Road was the shelter-in-place fire-hardened homeowners association building, along with a single truck. And the truck would then be donated to the local fire system. And it's been raised in that same earlier commentary. Nobody knows really what's the disposition of that truck. Wouldn't it be better served in an on-site at the homeowners association with fire training for the maintenance person? I mean, these are questions that that I think are desperate for an answer, along with, I'm going to transition now to noise and traffic, but the comments now have been raised about the traffic with White Wolf, traffic with the Chalet Road, exits from the parking lots at Alpine Meadows, and nowhere in the EIR did I see, I saw traffic, I read that the impacts would be slight, but again, since the county does have knowledge of White Wolf, county does have knowledge of the gondola, the people, when they get parked out at Squaw Valley, it's much more likely that when they get parked out at Squaw, they will then drive up to Alpine and try to use the gondola to get back to Squaw. All those kinds of ins and outs are not discussed in the EIR, and it's a critical factor in the parking and the traffic solution. And those intersections where White Wolf and this development come in again, in the EIR, it said that the expected impact will be slight, but there's no discussion of a solution. And I think that's critical. We read that maybe it would be signalized, maybe not, but it glides over. It glides over that. It's going to be a complex of nasty intersections on what do you call it, level F days. And then finally, that on that same traffic study, that was frankly, a 2012 study that got dusted off for a new possible interpretation. And the extrapolations to 2014 for traffic levels woefully missed the fact of 2018 and the 20-year build-out. This is, it falls far short. I think that particular traffic study, as an engineer, misses it badly. And I have no further comments. Thank you.
Thank you.
Thank you. I'm Michael Wilson. I'm a 15-year resident of Alpine Meadows, and I do live on John Scott Trail. While I wish I had some of the more technical aspects of the whole project and the concerns that some of the other people have voiced, I don't have the time in my day to do so. But I'll direct my comments more from just an overall general perspective. And I would ask of you, when is enough? How much more do we need? Can't we improve on the footprint that we already got? We really got to build out that much more? Listen to your constituents that put you in the chairs that you were sitting in. A lot of the comments you received already, you should listen to. You should direct your efforts more towards traffic in the area, in this county. We've got a huge problem with traffic. And some people want us to have the Olympics here again someday. You gotta be kidding me. We can't even get through Christmas week, let alone 4th of July. Some of you don't live in the area. You should come visit us 4th of July weekend, Christmas, and see what we have to put up with. Is there an alternative? Is there something we can do for Mr. Nelson? Is there a land swap where we can improve on some other areas in the county, in the area, to improve upon the footprint we already got? Do we really need more homes in this area? When is enough? How much more density do we need in an area where most of us who do live here full-time came here for in the first place, is to get away from the big city? So is that what this is going to come to 20 years from now, 50 years from now? Is our aim to get as big as San Francisco, Sacramento? When is enough? We move up into the elevation, into the mountains to get away from these big areas. There must be some kind of alternative to help the gentleman out and improve improve upon some kind of areas that need improvement. Let's focus on what we've got already, improving that, and not making our footprint bigger than it already is. To say that it won't have a significant noise factor, I can hear when Troy has weddings up at his property. I can hear the snowmaking guns at night, the grooming machines. I can hear Tim Granger firing up his chainsaw. It's a very sensitive valley. We can hear everything. We can hear nails being pounded. And to say this will be done and over with in 1 year, no. If the snow melts by July 4th, how much time is there to develop this? And this will go on and on and on again. And a lot of the people that live here full-time are here for peace and quiet, not for another 10, 15, 20 years of heavy equipment operating, nails being banging, et cetera, Again, thank you for your time. Listen to the comments, read those comments that have already been issued. Thank you.
Thank you.
Good afternoon, Mr. Chairman, members of the Commission. Thank you for giving us a chance to talk to you. I most likely are the oldest member in the room, or most likely one of the oldest people in this valley. I'm close to 98. I have lived in Bear Creek since 1963, longer than anybody else that talked to you today. I have 2 sons that live in Alpine Meadows, and I'm speaking for them. So the Wortham family is represented by 3 homes. I was a member of the Bear Creek Planning Committee for 27 years. During this time, I worked closely with Placer County Planning and Public Works. That was a very good experience. And I attended many planning commission meetings. None of you are old enough to remember. There's one person. And those meetings were very gentlemanlike. They never ate each other up, but they were very educational. And if this one person who might remember, the ruling was to cover slopes with grass. The grass would germinate and very quickly overcome all the native vegetation. We helped to develop a system of native plants, how to propagate them. There was nobody who was doing that at the time. And one time when I appeared before this commission, the chairman said, "Ernest, you know that we don't have those plants." And I brought up 2 flats of ceanothus, the squaw carpet, which is native in our valley, and said, "We managed to do the right sex and propagate them." I'm not a propagator, I'm a landscape architect, and all my interests are on that subject. I prepared an outline of many questions for Mr. Fish, but many of them were answered by him. And I want to thank him for his communication, echoing again Rochelle Latimer's. You people are doing a job, a very good job, and when he was standing here, he let us know, I know this project, only in some areas we happen to disagree. And those are the things that we will have to work out. When I was younger, which was not so long ago, my wife and I would work over this project. We would walk from Alpine Estates all the way up to the Stanford Lodge many times. In fact, our youngest son got married on the highest plateau. His marriage ceremony was there. So this lets you know the Wortham family is very much involved in Alpine Meadows. And I really want to second the people that came before us. Don't want to repeat things that you already heard, but there were many very good comments, and I think we have to do what you mentioned for the project before. We have to work together to find a solution. Thank you very much for listening.
Ernest, can we get your last name, please?
Wertheim, Ernest Wertheim.
Thank you.
Okay, not seeing anybody else stand up. So I'll go ahead and close the public hearing. And see from the commission here.
That last slide.
I have just a couple of thoughts and comments, and just to be cognizant. I appreciate the public folks here and Alex. Great presentation. In terms of the fire situation, someone mentioned the Oakland fires in '91. More acute, I think we need to take into account what's happening in Sonoma County, like the devastation there. I'm afraid that in a good way, we're going to learn quite a bit about fire hazard and how to deal with new communities. On the other hand, I think we need to look at it in terms of going forward with the project here, the Tahoe Basin area. As we all know, tinderbox and many places, and every time we add development, it's going to naturally exacerbate the situation.
We can't hear you.
I'm so sorry. Is that better?
Yes.
Okay. I was talking about the Sonoma County fires, and I think we need to look at that as a model in some way of learning what's happened. And I believe the state and local officials are going to look very carefully at what's occurred there. And going forward on any projects here in the Tahoe area, we're going to need to take a careful look at our fire procedures. Frankly, this is personal and anecdotal, but hearing people talk about sheltering in place as an alternative, a lot of people died, frankly, sheltering in place in Sonoma County, and I just cannot imagine that as being a useful tool in most circumstances. So again, I think we need to look to that experience and learn as fast as we can from the fire experts how to improve mitigation for new projects. Second, I agree with the folks who expressed concern about the White Wolf project, both in terms of traffic mitigation and also the fire situation. Again, I think going forward, whatever information we have, we need to incorporate it and look very, very carefully on those impacts. And it seems the common theme this morning also was the traffic study that was done. Everyone seems to conclude that it understated the impacts, and I'm not a traffic expert. I do know this Squaw Valley project is quite large. I saw what happened in this recent winter when we had gigantic snowfall. I saw where a couple of people died on the highway, or at least one person died. I think there's a lot of things we need to kind of look at in a global point of view when confronting any kind of new housing or other business project. And again, coming back, and it may not be apropos for this, but someone I think early on expressed concerns about affordable housing. And when I look at this situation here, I see that as a problem. And I always ask myself, well, what's the public benefit of any new project here in the Tahoe Basin? And how does that impact affordable housing for workers? Again, going back to Sonoma County, I happen to have lived there for a very long time, so I'm quite familiar with it. one of the big issues going forward is they can't even think about rebuilding there because so many of the workers cannot even afford to live there. They couldn't afford to live there before the fires. Now the housing stock is down 5,000, minimum of 5,000 units. And so again, all that needs to be thought through before we go forward on any kind of major project. Thank you.
Okay. A couple of questions for you. On the maps that we have, it's still showing an emergency access on the top end of the project, at least from your map.
Please get closer to the mic.
On the maps that we have, can you hear me now?
Yeah.
Okay, good. People across the parking lot. On the maps that we have, there's a reference to an emergency access that, as I understand from you, is not viable. It's not going to happen. So I'm not quite sure why it's still on the map. Because it's, the Forest Service is willing to work with them, and your neighboring development is going to work with them. So I know it's already been stated. We've got one access point, and that's it. But I'm not sure why. Again, it's still on the map.
So when we're dealing with a map instrument and we're getting dedications for easements, you get that opportunity when that map instrument is created. You may have it later, but that's certainly, there's uncertainty associated with that. So to provide certainty that if in the future there is ever a loop road that the Forest Service would allow to construct, because ultimately there is described in the Alpine Meadows General Plan a concept that a loop road would go through from about this location out right here where one of the EVA dedication points would be and connect all the way out, back out towards the entrance to connect back into Alpine Meadows Road out near the entrance of Highway 89. So the map would secure that future ability. Whether or not it would happen is there's uncertainty associated with it. There's also really, frankly, a relatively short distance overall between this other emergency access point and Chalet Road, which is right down here. But it crosses over U.S. Forest Service land, and I can't speak directly to the negotiations that Chris and his group have had with the U.S. Forest Service, except that I have heard them state directly to me that they don't provide access for the benefit of private development except under extraordinary circumstances. Those circumstances, in their judgment, don't occur in this instance.
On the structure, the difference between Plan A and Plan B, I got the impression there was a difference. Is it a location difference or is it a structure difference?
Yeah, so overall, and I should have mentioned in my presentation, I apologize to everyone that I did not. Alternative B is the applicant's preferred project now. Alternative A is where we began. Alternative B is now their preferred project. If they advance this, when we advance to an entitlement hearing, that is what they will be requesting approval of. The difference is a total of 9 units. On Alternative A, this area has 27 units. We're looking at Alternative B here. It has 1 additional unit, so 28 units. Overall, alternatives A and B in this area are largely the same. There are some subtle differences with where development would occur. These lots are pulled up real close to the road, so that these steeper areas at the back of the lot are not available for development. There's a wider stream corridor area that would be in common ownership, the HOA. We find that's a better management practice overall when you have sensitive resources to have them managed by the group. And then there's some differences over here. But the main difference really is the density over in this portion of the project area. There's a total of 10 units, cabin units, so those are effectively single-family residences that would be on these 10 lots. And in the Alternative A project, if I may go back to that, we instead have 14 half-plex units. So those are 14 half-plex condominiums. Effectively, they're like a condo in a way, and they're split down a common property line. So,
Alex, can I interrupt you? I guess my question was on the HOA building.
Okay.
Is there a difference? Okay. Is there a difference between the two projects
Yes.
in the location of the structure and the type of structure.
Yes, and I apologize, I did not understand that. So the HOA building on alternative A is here. If that project were to go forward, there's a mitigation measure in the draft EIR that says the emergency preparedness and evacuation plan that was developed for alternative B would have to be amended to incorporate the alternative A design. But ultimately, at this time, we kind of, as a team between the applicant and the county staff, decided if we can move off of alternative A, focus on alternative B, let's invest our planning efforts there. And they came up with the concept of these two lots here. The HOA building would be located on this lot. There'd be some additional overflow parking over on this lot. Be about a 3,000 square foot building, a little bit larger than what's contemplated over at the other site. The site is larger. This site is just under an acre. I believe it's 0.85 acres. And so it has area for a 3,000 square foot building, an associated 1,000 square foot HOA residence. Again, those structures constructed to a higher standard, and then there will be a small yard area, a storage building for the snow removal equipment as well.
This is probably not so much of a planning question, but a building question, but can you really put up a building that could sustain an intense fire? Like we've seen, as Norm was mentioning, in Sonoma County.
Yeah, and the lessons of Sonoma County I know are still being learned, and it's horrific and gives everybody a lot of pause. I will definitely make sure that Chief Schwartz is at the next hearing so that he can speak to those issues. I don't want to put words in his mouth, but I will tell you what he said at a meeting Doug Clyde and I had with him and John Collins in December. Obviously, evacuation is the preferred option, and you want evacuations to occur early on a voluntary basis. But that doesn't always happen. As we saw in Santa Rosa, people were getting minutes of notice. So you need an alternative. And in the chief's judgment, being able to shelter in place is a best available alternative. So when you have buildings with fire sprinklers, they're built of non-combustible materials, they meet all the other Chapter 7A requirements. There's a fuel management, fuel reduction plan to decrease the fire hazards on the project site, which is actually a benefit to the adjoining properties as well. And then if that is ultimately your option, that's your option, but even more to the point, the HOA maintenance facility, because you don't want to have to go from house to house to house to house, you want to be able to get to a single location and hopefully evacuate everyone from there. So a central rallying point. There would also be an electronic board, probably about this location of the project, that would be dormant, mostly. But if there was a fire event in the area, it would become active and it would have current information on what's going on. The HOA caretaker would also be pushing out information over internet and through text alerts, things like that. And there would be signage in the subdivision so that you know, effectively, can you evacuate, should you evacuate now, do it on a voluntary basis, so that there's early notification as much as possible. And ultimately, in the chief's mind, these shelter-in-place locations, they're not long-term, they're 1 hour, 2 hour at most. In his judgment, you have to get in, you have to get the people out. But it's not, the fire, as a lot of folks pointed to here, the emergency services that are available can be overwhelmed in an emergency scenario. You have to have other options available. And so that's, he was thought that, frankly, the modeling that was done for this project is a model that should probably be adopted for other projects in similar high fire severity zones where you incorporate these kind of provisions into a project.
I'm guessing his comments were before the Sonoma Napa fire.
It was December.
So it'd be interesting to have him follow up now
Absolutely.
in light of this, whether we might view this differently now.
Yeah, agreed.
Thank you.
I'd just like to make a couple of comments. First of all, I think the staff has done a good job on this, and I also want to thank the people that live in the area. Most of you that spoke today live in the area here. I don't live in the area, I live in Roseville. And in the past, I've pleased some of you with some of my votes in this area, and sometimes I haven't. So I've tried to evaluate the situation. But I saw the traffic, single access, and evacuation is some of the key points that that the staff will have to answer in the final EIR or get additional information. But I agree with Merrill here, this shelter-in-place business, I'm not quite so sure, I'm not an expert in it. I have a son who's a firefighter in the Consumnes River Fire Protection District out of Elk Grove, but he fought for the last 2.5 weeks up in Yuba City, and the Cascade Fire and the Tubbs Fire. He just came back a couple of days ago. So I will be asking him about how the fires, he's already communicated to me on previous fires that he's been on, when he's been dispatched through the forest, on just how quickly they spread. But someone here mentioned earlier about a more effective communication system. We've been hearing a lot about that some people weren't notified and some of the system broke down, whatever. So I think that's a critical part. As mentioned, that some of those people in Napa only had a couple of minutes to get out. I don't know if a siren is the answer, but I know some of the internet and also cell phones are probably one of the first things to go down. Most cell towers have no backup. I work for Pacific Bell, but also I worked for Nextel for a little while. And unless they've changed, in 2 hours, those cell sites are dead if the power goes out to them. So I think that's a critical point to the communication aspect of it. But I do appreciate all your comments. I know Alex was writing feverishly over there. I looked at him and I hope he got everything, but we'll have everything, and so that'll all have to be addressed on the final ER. But I do appreciate your comments. I appreciate your candor, and I appreciate you guys are really civil today. Sometimes in the past when I was chairman of this group, it didn't turn out that way. But anyway, thank you very much for participating today.
Thank you.
Okay, well, I just have one myself. There's, like we mentioned, the adjoining property owner is everybody in the United States, National Forest System property. And I didn't really see much reference to that in the environmental document. One question that comes up is the forest management plan that's been talked about. And that would be to facilitate, keep the fire on the ground and fire. I see several parcels adjacent to the National Forest boundary. I guess the question would come up similar to the idea of road access. Is this project really obligating the Forest Service to do work, fuel break, and that kind of stuff? It's like the questions, the impacts on the adjacent landowners, even if it is the National Forest System, should be addressed in the documents. So they're aware, they're exactly what those impacts are. We see on the shelter in place, I think the chief is going to be able to answer that question very well. I guess I used to work for the fires. Oftentimes, shelter in place is an idea that comes up to give the fire teams dealing with major conflicts the opportunity to manage the evacuations so you don't get everybody on the road at the same time. People get panicked, and maybe the fire's not approaching them yet, or they're not close, and everybody runs out and goes to the boat, and fire equipment can't get in, and the people can't get out. So oftentimes the fire departments will ask you to shelter in place, but they do then want to let people escape on their own time once they're notified. So that's what I think the fire chief will probably tell you, but probably.
And that is effectively what he said. Yeah.
Okay, well with that, thank you folks for your comments. Like it's been mentioned earlier, really appreciate it. This is a hearing on the environmental document, and the applicant and the environmental people are going to have a chance county to further address the questions that came up. So we'll give you another crack at the apple, and you all have the opportunity to submit written comments now too. So thank you very much. Thank you for being here. We'll see you next time.